says he has no instructions. Dismissed.
Weekly list old matter item number 2.
None appears. Dismissed. Non-prosecution.
Weekly list old matter item number 3.
3 may not have, what should be disposed of as because the order has been complied, madam.
All right. It's stated that the order has been complied with. The order under appeal has been complied with. The appeal is accordingly disposed of.
Weekly list item number 4.
None appears. Dismissed. Non-prosecution.
Weekly list item number 5.
None appears. Dismissed. Non-prosecution.
Weekly list item number 6.
1 minute. 1 minute. Item 5. She's there. Ms. Sahu, are you there for item 5? You have to unmute. Ha.
Lordship, I was not permitted to unmute.
Acha. All right. Tell us.
Your Lordship, it's a paltry amount involved. The question of law may be kept.
All right. The amount involved being insignificant. The question of law is left open for consideration in some other appropriate case. The revision petition is disposed of. All right.
Weekly list item number 6.
Here, my lord, so the amount involved is 54,000 some odd. But my lord,
That's all right. Then we'll leave it open. You say the amount of tax involved being insignificant. The question of law is left open. The petition is disposed of.
Weekly list item number 7.
None appears. Dismissed. Non-prosecution.
Weekly list item number 8.
my lord, no instructions.
No instructions disposed of.
Weekly list item number 9.
Here it is 30,000 some odd. my lord.
All right. Same amount is insignificant.
Weekly list item number 10.
None appears. Dismissed. Non-prosecution.
Weekly list item number 11.
11, my lord, 10,000 some odd.
Insignificant amount.
Weekly list item number 12.
I am appearing for the opposite party in this case.
My lord, may I place this matter, my lord?
Here the tax amount is 57,539.
Again, the tax amount being insignificant. The question of law is left open for consideration in some other appropriate case.
I'm appearing for the opposite party.
Weekly list item number 13.
None appears. Dismissed. Non-prosecution.
Weekly list item number 14.
None appears. Dismissed. Non-prosecution.
Weekly list item number 15.
May I please, your lordship, on behalf of Mr. Bose. My lord, your lordship directed to amendment of the petition because of some legible copy. But the petitioner has contacted, but he is not responding to it.
Then it's okay. You say counsel to the petitioner states that the client is not responding. That way, the matter the petition is disposed of. Right.
Bless you.
Weekly list item number 16.
I am from the opposite party, the hangman. In this application, I am for the petition matter. The item may be passed over. I am for the petition.
Passover. All right. Passover. It will come up now. He's asking for a Passover.
Weekly list item number 17.
Item 17 to 23, all are similar matters, but the office noting shows that the certified copy has not been filed.
It's okay, sir. In all these matters, certificate copy of the impugned order has not been filed for the last over 10 years. Clearly, no steps were being taken. The appeals are dismissed on non-prosecution.
21 and 22, their miscase has been filed for condonation of delay.
What's the delay, sir? I think some 2008 matter. $734 days. Okay. 754 days delay. In both these matters, you say there's an inordinate, unexplained delay in filing the appeal. The application for condonation is dismissed. Accordingly, the appeal is dismissed. 21 and 22. 23 and 24.
Item 23.
Yeah, same. Certified copy not filed. Dismissed on non-prosecution. 24.
Item 24.
None appears. Dismissed on non-prosecution.
Item number 25.
Wherever it is, you have to check if there's an interim order to vacate that. Yes.
Now the petition was, before this petition, challenging the order passed by the presiding officer Waqf Board. In way number 4 of 2008, that is under Annexure 3 minor.
So you can come here. 1 minute. Just keep the mic on that.
The president opposite part number 2 had preferred a suit that he is the Mutwali of the Waqf Board property.
Right.
So he seeks for a permanent rejection against the present petition. Challenging that order, the Lord Waqf Board permanently injected the present petitioners to come over to the suit property. And so far, my knowledge is concerned, my lord, the matter is going on a compromise table, my lord.
Sorry?
Both the parties are on a compromise, my lord.
You anyway compromise, sir. Why should we interfere with this? You do that outside of this.
And another the contracting counsel for the opposite party is there, S.C. Naik.
So you carry on that. Better not have a litigation then, sir. You'll compromise better.
So I pray that.
We'll pass a short order on merits, sir. We're not interfering. Petition is dismissed. All right.
Quickly list item number 26.
Milan Kanango.
Item 26.
None appears dismissed on prosecution.
Quickly list item 27.
Dismissed on prosecution.
Quickly list item 28.
Okay, dismissed on prosecution.
Quickly list item 29.
I am VC Miller.
Yes, please.
In this case, the award of the labor code has under challenge, Miller.
Right.
The fact of the case is that petitioner is an employee of Raukla Steel Plant and was taxated for unauthorized occupation company's land, for which repellable inquiry was initiated. Though in the inquiry, the finding came by the inquiry officer that the land was not occupied by the CAC, that is petitioner, but that was occupied by Eagle Club, and General Secretary was examined at DW1 and President was examined at DW2, and they said that the land was occupied by him, and the inquiry also they gave the finding that is kind of the Annexure 2 starts from page number 11. And let me turn to page 15, the last para. Page 15, Annexure 2, Miller. That is the report of the inquiry officer. The evidence of DW1 reveals that he is the General Secretary of Golden Eagle Club, which has been substantiated through the Exhibit 1 and 2. It is a fact that DW1 and 2 have enclosed the company's land. DW1, 2, 3 have admitted that the alleged structure has been constructed unauthorized on the said plot. During cross-examination, DW2 though confirmed the presence of other members of the club during the construction of boundary work, but could not say anything about the presence of the CAC on the said day. But the inquiry officer gave the findings and established the charge on the ground that the CAC was present on that spot on the date of inspection, but it is not a fact, Miller. I let my kindly say page 16, last para, Miller. Though the CAC has shown his ignorance about the name of the General Secretary Golden Eagle Club, but the report M Exhibit 1 confirms the involvement of the alleged construction. The document submitted by the CAC proved that CAC was not the General Secretary of the Golden Eagle Club, but the presence of the CAC on the alleged spot during the inspection cannot be ruled out. Even if it is considered that the CAC S. Panda is not the General Secretary of the Golden Eagle Club, but it is confirmed beyond the doubt that he was conducting coaching classes in computer to some students by taking unauthorized electric line of the alleged club. My lord, may kindly turn to page 12 Miller, same annexure Miller. No witness has stated that he was present on that day during the inspection Miller. Page 12. 8.1. During cross-section of MW1 has confirmed the presence of CAC on the alley spot on 23/1/2001, who were told to seek C. Kishan, that is General Secretary of the Golden Eagle Club. MW1 has also clarified that he had not seen the CAC during the inspection on the alley spot. That MW1 stated he has not seen CAC. Finally, let's test 9.1 Miller. During cross-section, MW2 could not clarify when the Golden Eagle Club was constructed, which was situated in the opposite side of this road of quarter number H679 and H680. AMW2 further clarified that after 23/1/2001, though he had gone to inspection, but during his inspection, he has not seen the CAC. And the AM Exhibit 1, the author of AM Exhibit C. Kishan, he was not examined by the management. Thereafter, but the inquiry established the charge on that ground, and that saying that by taking electric connection, he is conducting the classes. That is not the charge sheet. Though if they but also not confirm whether that electric connection is the name of the petitioner or not, that has not been examined. That no document has been filed by the management to that effect.
So we are not hearing a first appeal, sir. You have to point out what is so shockingly wrong about the impugned award. That's all. We are not hearing a first appeal. This is a 226. This is not a first appeal. We are not supposed to reappreciate evidence.
Yes, Miller. Miller may kindly turn to award Miller. Award is at annexure 5, page 19 Miller. That on the purpose findings, that's given the punishment, and the labor code has not scrutinized that. So there is a, I will file that is 32 Miller. That is findings of the labor code at page 32. It starts from 19, findings at 32 Miller. The power of the labor code in absence of section 11 are illustrated by this code Workman versus Firestone and Rubber Company Limited. When the inquiry is conducted fairly and properly in absence of any allegation of victimization or malafide or unfair labor practice, the labor code has no power to interfere with the punishment imposed by the management. Since section 11 is not applicable to the labor code because here they have reduced the basic pay. Section 11 is not applicable to the labor code, has no power to reappraise the evidence to find out whether the findings of the inquiry officer are corrected or not, or whether the punishment imposed is inadequate or not. In view of the fact, the court has no power to interfere on the punishment imposed by the first party management when the domestic was fair and proper. The domestic inquiry was fair and proper. Thereafter, they took the evidence whether the punishment is justified or not. The management did not give any evidence. My workman give 2 witnesses they have given. And the labor code also finding that they also stated, observe that at page 25 Miller, award, fifth line from 1 to 3, seventh line from bottom Miller. There is no incrementing materials elicited from the evidence of WW2 supporting the case of the first party management. However, he has filed again that is not supported by the management case. So they have not interfered the punishment. Labor code has not interfered on the ground that the inquiry is fair and proper. So we will not see the legality or justify whether the punishment is justified or not. So I have given one judgment of Supreme Court, Honorable Supreme Court, AR 2006 Supreme Court 2208. I have given one decision, Miller.
What is this for? What is the proposition?
That the proposition is the labor court has power. Though the inquiry is fair and proper, the labor court can interfere with the findings if the findings are perverse. Here the findings perverse. There is no witness stated that I have given that judgment. AR 2006 Supreme Court 2208. Last page, Miller. In this case also, the 11 is not applicable because here the labor code can I may place this parameter. In this case, the power of labor code in assumption 11A is illustrated by this code in Workmen of Firestone and Rubber Company Limited versus managed by 1973 1 SEC 81.
What is the proposition?
Conducted.
Sir, what is the proposition? There's no point in reading the judgment.
No, this proposition that they are not in this case, the labor code only allow the negative they give the award against the workman on the ground that once the inquiry is fair and proper, then we will not see whether the findings are forward or not.
Yes.
It is absence in this case. So that because the inquiry officer came to the conclusion, nobody has stated that he is present in that day. Not a single document is filed that meter connection is the name of the CAC. These are all perverse findings of the inquiry officer.
Yes. What do you say?
My the petitioner basically challenges this writ petition on mainly on two grounds. That is on page 6. That is ground 3. For that, the London court arrived at a conclusion that the court has no power to interfere on the punishment imposed by the first party management. When the domestic inquiry was fair and proper, is perverse, there has been a complete lack of application of judicial mind, and on the other hand, a superficial approach to the issues have resulted in a totally faulty award. Here, my lord, inquiry was conducted. He was fully participated with the inquiry. Thereafter, he was found guilty and a punishment was awarded, taking a lenient view. A stoppage of 2 basic pay has been awarded, and the labor code has taken the fairness of domestic inquiry as a preliminary issue. After holding the inquiry is fair and proper, the court has nothing to do except to interfere with the punishment. If the punishment is disproportionate with
Isn't the labor court supposed to examine the merits of the matter then? Once the inquiry is held to be proper, it should find out whether the punishment is justified, whether the finding of guilt is justified at all or not.
Yes, ma'am. He has taken the court below has taken evidence to that effect. Thereafter, under section 11A, he has to interfere with the punishment.
No, not this punishment. What about the finding of guilt itself? He has only found that the inquiry is fair and proper. Where has he gone into the merits of the?
During that process, he has gone to the merits of the case.
He's only gone through the procedure. He's only examined whether the procedure is just and proper. The law is very well settled. Once you find that the domestic inquiry is just and proper, you have to go next to the merits. What is the age of the man, sir?
Now he is working. He is in employment. Now he is at the time of filing, he was 38. Now 10, he may 40, 49 years, 50 years, about 50 years. 10 years are there. And every month he is leaving about 2,000 per month.
The challenge in the present petition, you have to go back. You have to go back. The challenge in the present petition is to an award dated 18 December 2010, passed by the Labour Court in ID case number 38 of 2006. The following dispute was referred to the Labour Court for adjudication. Take from para 1. Paragraph. As regards the charge against the workman for unauthorized occupation of the company's land and running a coaching center at the clubhouse for commercial purposes illegally, and thereby violating the standing order of the company. The defense of the workman was one of denial. Full stop. Paragraph. The Labor Court took up as a preliminary issue the question of fairness of the inquiry, domestic inquiry conducted by the management, and answered the said issue against the workmen in favor of the management. Full stop. However, issue 3 framed by the Labor Court concerned the merits of the management's action of finding the workman guilty and inflicting a punishment of reduction of basic pay by 2 stages. Paragraph. The court finds that issue 3 is only that, no? Mr. Ray,
Yes, Miller.
para 7, page 24,
Yes, Miller.
that entire discussion is only on the merits.
No, the labor court said that since he had admitted the exhibit A1 to 9, so he has no case. These all documents are exhibited before the inquiry officer, Miller. These all documents. So that's
But it is a discussion on merits only, sir. You made it appear as if there is no discussion at all on merits.
No, discussion, there is discussion. But the only ground is that because we have admitted that document, that all documents filed before the inquiry officer and that one exhibited by the management. So there is no scope to deny that the exhibit, Miller.
No,
There is no scope.
No, but there is a discussion. You made it appear that there is no discussion on merits. But there is a discussion on merits.
Discussion, but the labor code held that.
So this judgment does not help you, sir. Paragraph. Learned counsel to the petitioner. Say, learned counsel to the petitioner relied on the judgment of the Supreme Court in General Secretary, South Indian Cashew Factory Workers Union versus Managing Director, Kerala State Cashew Development Corporation Limited, AIR 2006 SC 2208, to urge that the Labor Court, after finding the preliminary issue in favor of the management, was required to address the merits of the action taken by the management against the workman. So, in the present case, the court finds that after holding the preliminary issue in favor of the management, the Labor Court specifically discussed from para 7 onwards the third issue, which is whether the action of the management by inflicting punishment on the petitioner was legal or justified. Full stop. In that process, the Labor Court has discussed extensively the merits of the matter. And that process has come to the conclusion that neither the finding of guilt nor the punishment awarded to the petitioner calls for interference. Paragraph. In exercising its jurisdiction under Article 226 of the Constitution, the court is not sitting in appeal over the judgment of the Labor Court. Full stop. Unless a finding of the Labor Court on merits is shown to be perverse, there is no warrant for interference with the award. So here the petitioner has miserably failed to do so. Full stop.
And fine is that only fair and proper. They have not said anywhere that it is not perverse findings. Never said in their order they're not.
Consequently, the court is not persuaded to interfere with the impugned award of the Labor Court. The petition is accordingly dismissed.
Kindly pardon me, my lords. Kindly pardon me, my lords. Item 28. In fact, I got confused, my lords. Got dismissed for non-prosecution. I'm there, my lords, to place the matter.
Sorry?
I'm there to place the matter, my lords. It got dismissed.
Proceed. Proceed.
Because this case is Barampur is an old town manners, old city manners.
Can you prepare one pass over your lordship? All right, I 28.
Weekly list item 30. Weekly list item number 30.
None appears dismissal number.
Weekly list item 31.
None appears dismissal number.
Weekly list item number 32.
Two, I am for the opposite party.
None appears.
I am for the petition. Copy of the counter has not been served. They are serving just now, my lord.
Tell me what the matter is about. Challenge to a labor court award.
My lord's labor court award, the wherein the petitioner's prayer for compassionate appointment of his son was rejected in place of his husband, my lord.
Yes.
My lord. My lord, the petitioner was entered into service in 1979, my lords. And
Petitioner's
continue,
father, you mean?
my lords.
Petitioner's father,
Petitioner, sorry, my lords. Petitioner husband, my lord.
husband. All right.
Petitioner husband entered into service in 1979 and continued till 1989. And in the meantime, two schemes were floated
So
for.
by now she must superannuate, sir. She can't be taken.
No, my lord, she died, my lord, during service.
She died.
No, the petitioner's husband died.
What is the petitioner's age, sir?
My lord, pardon, my lord.
What is the age of the petitioner? She must
Age,
be
age.
above 60 by
My
now.
lord. But the compassionate appointment was sought for his son, my lord. For her son.
How can it be? You applied for compassionate appointment for the petitioner or for the petitioner's son?
Petitioner's son, my lord.
But he is not a party.
No, my lord. He
Ah,
is
then?
not. My lord, sab, at the time,
Even in the labor court,
my lord.
the son was not a party.
No, my lords.
And then where's the question, sir? We can't have a proxy litigation like this.
But the honorable labor court has decided it on merit instead of that ground, my lords.
No.
Yes, my lord. That
The
point has
question is
not been
not
dealt
about, the question is not about the son. See what is the question referred to? Look at the question
Madam.
referred to the labor court.
with.
Awards, sir, come to the award.
My lords. Yes, my lords.
Come to the bottom. Please read that.
Yes, my lords. Dependent family member of the deceased workman. My
That's right.
lords. Yes, my lords.
Ah,
And here,
obviously the wife was a dependent family member.
my lords.
Which is why she filed this petition.
Yes, my lords. My lords, fact is after the.
That can't change the
petitioner-
fact, sir.
Yes, my lord. After
If the son
petition-
was asking for compassionate appointment, he should have filed it.
What has been passed, said in
Just
the-
come to the bottom of page 11.
my lords.
You'll get the answer.
Yes, my lords. Shall I place it, my lord?
Page 11,
My lords, I'll place it.
bottom,
My lord.
kindly read it.
My lord, sir. In course of time.
No, bottom, sir. So
During
the
the pendency
disease.
of the dispute, he died on 2389. Thereafter, the second party approached the management to give her employment under the rehabilitation assistance scheme.
So stop there.
My
So
lord.
who approached the management?
My lords, the petitioner. Your lordship may kindly have the next line only. Yes, my lords. Page 12, my lords.
Yes.
Though the management assured that her son on attaining majority would be given employment and also persuaded her not to press for the deceased claim for regularization, the management refused to give employment to her son and he on his attaining majority on the ground that the deceased had not been regularized.
No. So why did the son not file? Why did the son not file the petition then? He's not a no longer a minor, he's a major.
My lords, at that time, he just attained majority, my lords.
Then why did he not file? So anyway, he is not regularized.
My lords.
The
That is
deceased
the
workman
claim
was
that
not
he was-
regularized. He was an
He was
NMR
not
worker.
regularized, and since he was not granted any compensation under Workmen Compensation Act, that's why he is not eligible. That's why his family members are not eligible for.
So what is wrong with that finding? And the dispute was raised 11 years after the death of the deceased
After
workman.
20 years, madam, 20 years. I have abandoned para 6 of my count.
No, my lords,
Dispute is raised after 20 years. Date of death is 1989. Raised the dispute in the year 99.
my lords, that
10
I'm
years,
clarifying.
sir.
That I'm
My
clarifying.
lord,
It was
after 20
converted,
years,
my lords.
After 20 years, a dispute is raised.
Sorry?
20 years, a dispute was raised. ma'am.
Who's, I think my arithmetic is very bad, sir. What, how about your arithmetic? When did he die, sir?
Dies, my lord, in the year 1989.
Then when was the dispute raised?
My lord, what happens, my lord? The petitioner was the.
No,
husband
just
of
answer the
petitioner.
question. When was the petition dispute raised?
The dispute raised, my lord, in the year. Dispute raised in the year 2008, my lord. Reference was.
Firstly, it
Not
was
reference, dispute.
Dispute, my lord, that I have, not my lord.
firstly it was raised in 2001, thereafter in 2008, my lords.
Even if sake of argument, my lord, it is.
No, I'm just stating the facts, not for argument.
No. Also page 18 top, sir.
My lord, what
The
happens-
dispute was raised 11 years after the death.
My lords.
So don't make 11 into 20. That's all I'm trying to tell you.
Oh, 2008 reference was there. 2008 reference was there.
Dispute was raised much earlier, sir.
My lord, that, not. My lord, my response submission, what happens, my lord? The husband of the petitioner working as a NMR employee in the establishment of the NESCO. What happens while the Orissa state Railway was functioning? Then, my lord, the GIDCO rehabilitation rule is not applicable since he is working NMR employee. Only GIDCO rehabilitation rule is applicable to the regular employee of the all the electrical establishment. My the GIDCO now para 10 of my counter may kindly place, my lord. Para 10 I have details, my lord. Since he is another employee, the GIDCO rehabilitation rule is not applicable to the case of the petitioner. That is the one of the ground. A second ground, my lord. Second ground, the dispute was raised after 11 years to 12 years, which is also not maintainable in the eyes of law, so far as section 10 of the.
There she
idea.
says he's waiting for her son to become the major. That's why.
Yes, my lord.
That's a valid explanation.
That is only my ground.
So you have no problem that the son did not file the petition. That's not an issue with you.
That is a mistake.
No,
I
no,
cannot.
I'm asking him.
My lord, my lord.
You have no problem that the son did not come forward to file a petition.
My lord, they filed, my lord.
Okay, all right.
Rather, my lord, is not maintainable since his father was an NMR employee. The GIDCO
What do you
rehabilitation
say
rule
for
is
that?
also not applicable.
That is
The
an
rules I have also
NMR.
enclosed in the
My lords,
annex
they are
A
saying-
and B.
My lords, I'll show you, my lords. So lords, you may kindly have a glance at. Yes, my lords.
Para 1 of the.
Your lords may kindly have glance at page 16, my lords.
Annexure A, para 1, I have categorically stated. Page 9 of my counter, annexure A.
Yes.
But I have filed the rehabilitation rule under annexure A. Para 1 clearly stipulated that. May I place the para 1 of the rules, my lord? Rules, my lord. The rehabilitation assistance scheme shall be applicable to all the salaries of the employee workers board born on a regular and purchase establishment, but shall not apply to the NMR, CLR and other employees. my lord.
Let me ask him, sir, what is
My lords,
response?
that is what I am showing. My lords, your lords may kindly have a glance page 16, my lords.
Yes.
Finding of the learned presiding officer tribunal.
Yes.
Yes, my lord. From last line, my lords. Therefore, the letter smarter. Relying on exhibit 2, it is argued for the second party that it is at an instance of the management's giving employment to the legal heirs of a deceased employee, namely Raghumaji, who was an NMR. But a careful reading of exhibit 2 reflects that for the death of Raghumaji, compensation was paid. That is, their stand is if compensation is paid, then only NMR can be, dependents of the NMR workers can be given compensatory appointment, my lords. It is their stand, my lords. So,
What is your stand, sir? How do you say that you're eligible for compassionate appointment despite the disease being NMR? That is what you have to answer.
So, my only submission is that it is not a matter of, I cannot claim it as a matter of right, my lords, but
But the
for,
scheme itself, the rule itself does not permit it,
my lords,
and they cannot act contrary to the rule.
only these dependents
All
have
right.
no other
You say the
source of
challenge in the
income.
present petition is
That's
to
the only
award
my ground,
dated
not that way.
28 October, 28 September 2010, passed by the Industrial Tribunal Bhubaneswar in ID case number 254 of 2008. The following dispute was referred to the tribunal for adjudication. Take from the first paragraph. The ground on which, one of the grounds on which the reference has been answered against the work, against the petitioner herein, is that her husband, namely the deceased workman, had been working as a non-muster roll worker, bracket NMR, under the erstwhile management of the Orissa State Electricity Board since 1st December 1979 till his death on 20th March 1989. Stop. On 1st April 1996, the management was transferred to the Grid Corporation of Orissa Limited. And with effect from 26 November 1998, it was transferred to the Northeastern Electricity Supply Company of Orissa Limited, bracket NESCO, bracket. It was sought to be argued on behalf of the petitioner that in terms of a tripartite settlement, the OSEB had framed a scheme in 1981 which provided for regularization of an NMR who had completed 400 days of continuous service as on 1st September 1981. So it was accordingly contended that the deceased was entitled for absorption in the post of helper as he had completed more than 400 days of continuous work. Paragraph. There was a subsequent scheme regarding absorption of NMRs. However, as it transpired, the disease was never regularized in service. He had raised a dispute in that regard, but during the pendency of the dispute, he expired on 20th March 1989. Paragraph. As far as the rehabilitation assistance scheme is concerned, it is clear that there was no scheme by the new management, and the one framed by the earlier management was repealed with effect from 29th March 1996. Stop. The finding of the tribunal was that under the scheme as it existed, only regular employees only the dependents of regular employees who had died in harness could be considered for rehabilitation assistance. The rule specifically, the clause in the scheme specifically excluded NMR workers. Full stop. As in the date of his death, the deceased workman was only an NMR worker. Full stop. Paragraph learned counsel for the petitioner was unable to point out how the petitioner would be entitled to seek benefit under the rehabilitation assistance scheme when it clearly did not apply to dependents of deceased NMR workers. Full stop. Consequently, the court is unable to find any error having been committed by the tribunal in passing the impugned award. The petition is accordingly dismissed.
Weekly list item 33.
My lord, may I pray, my lord? On behalf of the opposite party, my name is written.
Lord, item 27 non-appeals order is passed.
Who's in item 33, sir?
27.
Item 33.
Who's for the petitioner? Item 33. None appears to the petitioner. Dismissal not prosecution.
34, 35, similar.
The 34. Hello, item 34. Hello, item 34.
Yes, please.
Item 34.
Very similar. Item 34 we are for the Union of India, my lord.
33, 34, 35, similar.
None appears for the petitioners. Dismissal non prosecution.
35.
My lord, Union of India appearance may be noted, my lord.
Item 36.
But item 36 is same and the batch of cases which has been fixed to 12th of May.
Sir, isn't this company before the NCLT?
Yes, NCLT, my lord. Now,
Then we can't proceed with the matter if an insolvency resolution professional has been appointed.
but in fact, the batch of cases, let it come on 12th May so that it can be disposed of or taken into consideration.
All right. But it will be pointless, sir, because none of the petitions are supposed to be dealt with by the court once the insolvency resolution professional has been appointed.
But that yours is absolutely correct. But here, as it appears, actually, there has been amendment has been made with regard to change of the petitioner's name, the Tata Steel now by virtue of the Bombay High Court NCLT order.
I see. All right. 12th May, is it?
12th May, my lord.
All right. List on 12th May.
List item 37.
Right, please. I am in VC, my lord. The claim in this case is the yardstick prescribed to the granting aid order 2008 under annexure 4. My lord, the state government, the brief fact of the case is like this, my lord. The state government has prescribed a yardstick for appointment of staffs, non-teaching and teaching both, in different government circulars. First was in 1977. Thereafter, my lord, council has adopted the same principle for the junior colleges in the year 1982, and it was continuing. In the year 1994, a revised yardstick has come along with the granting aid order 1994. And 94 granting order was repealed in a subsequent granting aid order 2004, and there was no yardstick prescribed therein. And after supersession of all these granting aid order, my lord, in 2009, two granting aid order came into force. That is, one is granting aid order 2009 and granting order 2008. Granting aid order 2009 is applicable to the institutions, as I have given the 2009 granting order also. It is applicable to the institution, those who are in receipt of granting aid. And 2000 granting, in brief, my lord, this is the fact. 2008 granting aid order is applicable to the institution which is yet to be brought into granting aid 4. But what they have done, so far the 2009 granting aid order is concerned, they have made applicable to the pre-revised granting aid, yardstick prior to 1994. Here the petitioners who have also appointed prior to 1994. But while giving granting aid, there is a discrimination into these two granting aid order. When in a normal college, my lord, 3 posts of clerk are available for the 2009 granting order. For this 2008 granting order, only 1 post of clerk has been made applicable in this new yardstick. Though all were appointed prior to 1994. And my lord knows that 94 granting order has been repealed and that has also upheld by the Honorable Supreme Court. And that is why, my lord, though we are appointed, the persons appointed in 2000 granting order and these persons, those are appointed in 2008 granting order type of colleges, now appointed in one time, now the number of posts into the granted fold in the consequence reduced so far our college is concerned. And that is why we have been debarred to receive the benefit of the granting aid. Merely because the state government introduced a new yardstick reducing the post in 2000 granted order. That is
So-
why I am challenging.
No, there's no interim order here, and I think now there is subsequent granting aid orders.
No, that is in continuation to this. That new granted order has no change. These 2008 and 2009 granted order has been revised further. The quantum of salary has been increased in 2017 granting order. But so far the yardstick is concerned, my lord, that remain one and the same. So that is why, my lord, though we are appointed at the same time, and the institution after became added, they come into section 10C of the act in a common cadre. And these persons are intertransferable from one institution to another. But though because we are appointed in such an institution which was not brought into the granting aid fold, we have been debarred to granting aid. Though at the time of appointment, the yardstick of 77 was in force. And our appointment was on the basis of those yardsticks, basing on which now the person, those who are under 2009 granting order, getting the more benefit. So now only 2 peons are getting granted in 2009 granted order, 2008 granted order institution like us. Others have been debarred to their salary. But those are appointed along with us in other colleges, now they have been brought to the granted. This is my whole case, my lord, and I am about a case on discrimination.
Yes, Mr. Budili.
Here I was verifying my record, a notice has not been issued.
It was in the single bench, the direction was given to extra copy. Thereafter, my lord, I referred to my lord in the division bench.
Notice has not been issued till now.
Till now, no notice issued.
I will serve copy.
So your clients are clearly not interested in the matter, sir.
No, my lord, they are interested, but the people are not getting anything. Though they are
No, how can a matter is pending here without notice also being issued for 10 years?
No, because this, my lord, the difficulty is this was filed and listed before the honorable single judge. Single judge have kept the matter pending for some time, thereafter referred to the larger bench, to the division bench.
No, that was referred in 2015, sir.
My lord, thereafter it could not be listed, my lord.
Why?
I have no answer to that.
No, if your clients are really interested, I'm sure you have
Yes, sir,
got
they are
it.
interested. They are interested, my lord.
No, they've
I've
gone to
also taken
sleep, sir.
steps. I've
Either
also
the
taken steps.
no steps are taken.
Yes, I've given memos only before the deputation and it could not be listed.
This has come up today on its own. Otherwise, it would have
Yes.
never seen the light of the day.
And all the fault cannot be blamed on me, my lord. If it is because the quoters were not listed, my lord, it will decide.
Wow, no point now issuing notice, sir.
My friend is the only state is there, my lord.
No, he
I've
says no
given the-
notice has gone to him till date. There's no notice, therefore no instructions, no reply, nothing.
No. As per the High Court rule, I have served the extra copy on my friend.
But he's not obliged to file a reply unless we issue notice.
That is up to my lord. And the claim of the petitioner persists as on date, my lord. Because unless some order is passed in this case, they may not get for their lifetime. They will not get the benefit.
Why?
Because now, because the change of yardstick.
No, if there's a change, then anyway they won't get it then because the new rules will apply.
No, new rule has nothing to do. That is why I have stated the brief history of the case, how this discrimination the government has made. So persons appointed in the same type of institutions now brought under the 2009 granting order, for them the yardstick of 1977 has been made applicable. For the petitioners, those are appointed at the relevance time when this 877 yardstick was there, but now they have been forced to come into the 2008 granting order after our appointment. At the time of appointment, this 2008 granting order was not there. And kindly see our appointment are 93, 94 like that. At the relevant time, 77 yardstick was in force. And for them also the same principle throughout the state. But they have been favored. They will govern under the old yardstick, but now we have been forced to receive the under the new yardstick, and that is why the post has been reduced. So far the grantee is concerned. Persons are continuing.
No, sir, the present, the petition has not been amended also by you to account for the subsequent grantee orders.
No,
Every subsequent order will repeal the earlier order. Will it not?
No. This is not that way, my lord. This 2009 grantee order and 2008 grantee order came in one day, 7/1/2009. That is the date of notification of this order.
No,
So
no.
government-
All orders survive. Is it? None of them is repealed.
Pardon, my lord.
Every time a new grant in aid order is promulgated or made, it will not repeal the earlier one. Everything will coexist.
No, just I am repeating one second to answer, my lord. 94 grantee order repealed the earlier principles. 94 grantee order repealed in 2004. But till 2004, my lord, there was no yardstick. Yardstick of 77 persist. In 2009, 7/1/2009, these two grantee order, 2008 grantee order and 2009 grantee order came into the statute book on one date, that is 7/1/2009. And there is the discrimination. What they have done, so far those who are covered under 2009 grantee order, they have been paid the benefit.
Anyway, Mr. Mudali, now that you know the matter, you take your instructions then. Mr. Mudali seeks time for instructions. List on 29th June.
Weekly list item
Yes, sir, 2
38.
extra copies, my lord.
Yeah, extra copies be served on Mr. Mudali. All right.
Wait, please, Lordship. Let the Lordship may kindly see order dated 2015-2017. The Lordship will be clear about the facts and all that, because by that order, Honorable Court had appointed Advocate Commissioner, 2015-2017. If I permitted to read it, 2015-17.
Yes.
Had Paravan concerned some land of the petitioners in WPC number so and so was taken by the government, and in exchange an area of 107.5 decimal was allotted in their favor by the government in G department from plot number 480 and 483. The allotted land had Vidut mark on one side and had proposed that 20 feet wide road on the opposite side. Two counter affidavits have been filed by the state government giving conflicting statements. In the first affidavit dated 11/9/2012, it was stated that as per the report of the RA dated 14/6/2007, Annexure B, the spot land has been reduced to some extent and there is no existence of 20 feet wide road as proposed in the drawing. In the recent counter affidavit dated 15/9/2017, it was stated at para 3 that a team of officials of J department and PG department along with the supervisor and omits remeasured the land on 12/7/17 in the field and found that land measuring 107.5 decimal is very much available at the spot which is lying vacant. It is also stated that proposed 20 feet wide road situated to the west of the case land is encroached by the neighbor private landowners, which is not at all relevant to the present case as the petitioners have proper access to.
Appointed Mr. Mahapatra as advocate.
So,
In fact, if I remember correctly, just now my learned senior said me about this report. In fact, it was heard by division bench of Justice B.K. Nayak and Justice Chaudhary then. This case was taken up on the next date. We filed that, but it could not be ascertained then. I have a copy. My lord should put up tomorrow. My lords, I will get that copy and submit it. Because on that particular date, it could not be taken up. We mentioned it and filed it. That is how it could not be ascertained.
Subsequently, also, your lordship directed on 20th March 2018 to your lordship directed the State Council to file the sketch map and all that.
Sketch map by GA department.
By GA department.
That I have, my record shows we have supplied it to Mr. Mahapatra, I think.
No.
No,
That is on 20th March 2018.
But sir, we have taken help of GA department omins and there we prepared a map and we have enclosed it to the report and submitted it. That copy, I think I will be having a copy of that. My may take up tomorrow. I will file that copy for my.
May I request one thing to your lordship? Your lordship may kindly take up the third connected matter, that is Pramila Mahanti versus State of Orissa 5802 of 2006.
Yes.
Because that has got serious connection with the first matter.
Yes.
Because there was a status quo order in that case, And that matter is to be heard at the first instance. That is my, Mr. Mahanti is there, I think.
Yes, I am appealing for the petitioner in that case. If you also takes up that brief, there is a sketch map contained under Annexure 4. Annexure 4 is at page 16. It continues up to page 24, where is a sketch map. Page 24. Kindly have a glance at sketch map. Now, this Annexure 4 is a document of exchange by the government in favor of the opposite party, present private opposite party. Here, let me kindly mark, there are 2-3 plots. This plot number 1266 and 1265. These two are private plots belonging to the petitioner. Then, after these two plots, there is a proposed road. It has been left out of plot number 480 to approach the main road, main Vidyut Marg. Now, beyond that proposed road, there is an allotment shown in yellow color in favor of my learned senior's client, the petitioner in the other case. Now, the only grievance of this petitioner, present petitioner in the 5802 is that this proposed road should be left open so that the private plot owners can use it. Because there was a threat of encroachment by the subsequent allottee from this plot number 480 and 483, the dispute came up. In that connection, this honorable court also directed my learned senior Mr. Mahapatra and the other agencies to submit the report. And my sole grievance is that road must be left open so that the petitioner in the present, both the same piece, they can use. This is in front of my private plots.
No, in the interim, what has happened? This petition has been pending for more than 60 years now.
It is just like that, madam. It has been had
till
2018.
Let me,
it has been had number of
Lordship
times.
will permit me, let me submit one thing. So far as this vacant land is concerned, it is a subject matter of exchange. It is our land. And most importantly, your Lordship may kindly see my counter affidavit as page 2 at para 5. We have stated that this petitioner, Pramila Mahanti, she has filed a civil suit in the court of the Civil Judge Senior Division Bhubaneswar, claiming her title by virtue of adverse possession over that particular piece of land.
Oh.
So this plea of adverse possession vis-a-vis the claim of right of way, easement of right of way are inconsistent to each other. That is my response. If you have approached the civil court with a particular right of right title interest on the basis of adverse possession, then you cannot claim that this property may be left open, then the government cannot utilize the property for exchange purpose, for allotment purpose, and something like that. So I don't know what is the fate of that suit, title suit C600 of 2006, which is filed by this Pramila Mahanti herself.
So you can't have parallel proceedings anyway.
That is what I have stated in para 5 of my counter. You cannot maintain a parallel proceeding, and on one hand you will claim adverse possession, on the other hand you will you insist the government that you should keep it open, you should not utilize it. It is a parallel claim.
No, that suit, my learned senior is referring to that. In the meantime, it has been dismissed.
Maybe if it is dismissed, then it is dismissed.
Correct.
But you had made a claim of adverse possession over that particular piece of land, which is the subject matter of this writ petition.
Lord, what I beg to submit, accepting the document of the government, this annexure 4 is the government's document. They have left a road for use of the party by the private parties and the next subsequent allottee also. That road must exist as a road. That is my sole grievance. Accepting the annexure 4 is a document of the government in favor of the present opposite party. In the document of the government, in the exchange deed itself, the plot which has been allotted in favor of the present opposite party.
My lord, may beg to my responsible submission is that by an order of this honorable court in OJC number 12771 of 2001, we were constrained to allot this land to private opposite because there was an order of the honorable high court, and you have got alternative passage. You had claimed adverse. These are the cumulative facts which your lordship must consider while considering the claim of the petitioner in this writ petition. Your claim of adverse possession has been dismissed by the appropriate court of law, and we have allotted it to some other persons by order of the honorable high court. In this background, my responsible submission is that you have no claim over the property. You have no locus standi over the property once the suit is dismissed.
Lord, I have no quarrel, no dispute over the document of the government, document in favor of the opposite party. That's why I am repeatedly submitting, Lord. I am accepting that document. Even accepting the document of the present opposite party, the government has left a passage That must be protected. That is my sole grievance.
What is your stand of the passage? What is the stand of the government on the, because that is very basic. You cannot have an objection to.
No, so far as this passage is concerned, it is not a case that they have no alternative passage. They want an additional passage. And so far as this private plot to approach the main road as proposed by the, your lordship may kindly have a glance over the prayer portion. Directing the opposite party number 1 and 2 provide appropriate roads from their private roads to approach the main road as proposed by them in annexure 4. This annexure 4, lordship may kindly have a glance. They need an alternative passage over a government land, which is according to them in annexure 4 earmarked as a passage. But this land has been allotted to somebody else by means of a deed of exchange, and that is by order of the Honorable High Court. That is our stand. And it is not a case that you are going to be landlocked if this passage is not given to you. So there is no violation of the fundamental right of the petitioners, and they are not landlocked at least. It is in the heart of the Bhubaneswar town. And this passage, once upon a time, it was meant for passage, but subsequently the characteristics of the land has been changed. And my learned senior's friend, client has been allotted with that land.
With due respect to my learned senior, this passage has not been allotted in favor of the opposite party.
That is,
no, passage will be like a common area, wouldn't it?
Yes, government area. This has been left.
No. A passage is like a common area. It won't be allotted to any particular person.
Common area, yes.
So there's a question of allotting that passage.
Yes. I also do. I agree with.
No, he's only questioning your locals. He says there are other routes to come to the land.
It is available in the sketch map. There is no other route.
Said so. There is no such assertion in the writ petition, I think. My learned friend may show the relevant paragraph where he has said that this is the only access to the his private plot.
It can be ascertained that report.
No, report. That must be some assertion in the writ petition that this is the only access, and if it is blocked, we will be landlocked.
Yes, let my learned senior show what is the alternate passage.
That we have to submit the sketch map.
Because the exchange deed which is there, it shows
Yes, my
plot number 480.
Yes, my lord.
That is the passage which is meant for the allottee.
Yes, my lord.
But what is the passage which is to be used by the petitioner?
That alternative passage which I mean, that is I have to show by means of a sketch map, because that cannot,
Mr. Mohanty states that he will present on the next date a sketch map.
My lord, it is better that Mr. Mahapatra's report should come to the record, because that will perhaps suffice everything.
In the present case, Mr. Dayananda Mahapatra, learned counsel, had been appointed as a commissioner.
Along with Mr.
Because
Siddharth
all the
Mishra.
cases are.
Along with another advocate, Mr. Siddharth Mishra.
Along with one Mr. Siddharth Mishra, learned advocate. They have prepared a report, a joint report, a copy of which has to be placed on record. Mr. Mahapatra states that he will place it on record within a week. Paragraph.
My lord, copy may be sought on.
Yes, copies of these said
So that I
report be
get
served on
instruction.
counsel for the state as well as petitioner. Paragraph. Mr. Mohanty will place before the court on the next date a sketch map showing the passages available for approaching the plot in question.
Obliged.
Alternate to the one in respect to which the petitioner is seeking relief.
This one.
List on 13th July.
Public.
Weekly list item 39. Item number 39.
None appears this was not persuasion.
Weekly list item number 40.
My lord. Cancellation of lease, my lord. I am the
Sorry?
purchaser. Cancellation of lease. I am the
Same
purchaser.
order.
Yes, same.
Yesterday, what was the item number?
Item number 40.
to 40.
Same order.
Only your lordship may clarify, because the entire extent of lease which was granted to the original lessee, that of 5 acres. Out of 5 acres, the petitioner has purchased only acre 0.200.
Whatever he proves, he go back. That's all.
Yes.
Tasmaka will determine all those questions.
No, that impugned order is in respect of entire 5 acres of land. But the petitioner's interest is only in respect of 200 decimals.
Okay, we say only in respect to the petitioner's claim. All right. Only insofar as the petitioner's claim is concerned, the matter is referred back to the Tahsildar. Passovers.
Weekly list pastoral matter item number 16.
It is your lordship. I'm on VC. But here is a short date chart I've prepared for your lordships. The present petitioners are bona fide purchasers of the suit land, which have been purchased from opposite party number 2, which is a builder. Now, Lord, pursuant to the purchase of at least one of these sale deeds, the land was mortgaged with the bank without the knowledge of the present petitioner, and that those properties were put to auction. Now, Lord, those by virtue of this honorable court's order, the first order is Lord 4/10/2010, where there was, as an interim measure, it was directed the property in question may be put to auction, but the sale shall not be confirmed without the leave of the court. Now, subsequently, my lord, there was another auction that was published in the newspaper, and the petitioners filed an interim application to stay the auction. And if your lordships kindly see, order dated 29/6/20. But there, since no auction took place, there was no purchase.
I am appealing for the bank, my lord. My lord, this application is not maintainable in view of the fact that possession notice under Surface Act has been challenged by this.
So the mic is not working or something?
No, it is not on. My lord, this writ petition is not maintainable under law, my lord, because possession notice under Surface Act issued by the bank.
What possession of?
Issued possession notice, my lord, under Surface Act is under challenge, my lord, in this writ application. Surface Act.
Who took possession under the Surface Act?
My lord.
Who has taken the possession under the Surface Act? OP number 1.
Symbolic possession only.
Symbolic possession.
Only symbolic possession, not physical possession. My lord, they have got alternative remedy to prefer appeal before the DRT. Secondly, my lord, there are 3 writ petitioners. 3 writ petitioners have filed 1 writ petition. Property has
Who's for the other side? You're for the other side.
I'm for the petitioner.
Everybody's standing up together, all together. No one for the bank.
My lord.
Who's appearing for the opposite?
My lord, I am appearing for the bank.
All right.
My lord, I am opposing the writ petition.
No, who's for the petitioner?
I'm there for the petitioner, my lord. I'm on VC, my lord.
Right.
But here, in fact, the petitioners were never noticed because they have purchased the lands prior to the lands were mortgaged by the vendor, my lord. On the date of mortgaging of the lands to the bank, the vendor had no title anymore. That is the claim of the present petitioners, my lord. And on such account, also, this honorable court protected the properties. There's an order, or interim order.
On 4/10/2010.
Yes, my lord. And subsequently, that was also modified Modified in the sense, my lord, it was held that since no one participated in the auction that was published subsequent to the filing of the writ petition, therefore the learned counsel for the bank submitted that auction of the property was scheduled, but no, it has failed because there was no bidder.
The original borrower has not appeared.
But Patra Builders, he has not appeared. Fresh
Borrower-
notices were also issued.
Borrower has appeared.
Have they been served?
Miss Dipali Patnaik has appeared. She was present in first hour, my lord. Miss Dipali Patnaik. Dipali Mahapatra, my lord. I'm sorry. My lord, borrower has availed loan.
No, but there has been a valid sale, sir, much prior to your mortgage.
My lord, with regard to mortgage, my lord, kindly see at page 8, I have filed mortgage document with regard to mortgage, when it was mortgage and when the sale deed was executed.
Mortgage is 21st July 2005.
Mortgage was dated on 5/11/2005, but property was offered sufficiently prior to.
No, what's the date of the sale deed to the petitioner?
Sale deed, my lord.
But the date of the sale is
Sale deed, my lord.
sale.
There are 3 sale deeds at page 34, 50, and 59. At page 34, petition number 1 sale deed. 34 of the writ petition.
Page 34.
34.
No, give us the date, sir.
Date, my lord. Date is 12/8/2005. Petition number 1's register sale deed. Then petition number 2 sale deed 27/12/2005.
So your contention is that all of this is subsequent to the mortgage?
No, my lord. Petition number 1, only petition number 1 is prior to mortgage. Petition number 2, 3 not.
Are subsequent.
Subsequent. But petition number 1, my lord, even if it is prior, my lord, but this property was offered by the borrower prior to that. Sorry, after that. Kindly see, my lord. I have filed the document with regard to mortgage. Offer and property was offered on 5/7/2005. 5/7/2005 property were offered. Intention to create mortgage. Then mortgage was created on 5/11/2005. But the intention to create mortgage.
That's at page 93.
Prior to.
Annexure B1.
My lord.
So these were not prior sales, Mr. Mishra. They are subsequent sales.
What my humble submission is, till the time the properties were put to auction by virtue of the impugned notice, there was no knowledge of the process of under the second.
No. So you should proceed against that Pratima Builders or whoever sold it to you. Your vendor is Pratima Builders.
Pratima Builders will.
So you'll have to proceed against them.
Well, this is an internal document insofar as the offer is concerned, but the properties were actually put to mortgage pursuant to my sale, my lord.
No question of putting to mortgage. Look at it. Come to Annexure B1.
Yes, my lord.
This is the deposit of title deeds.
Yes, my lord.
Yes, my lord.
This is, we have on 5th July deposited with you.
5/7/2005 on July.
So that's the date.
My lord.
So it's not subsequent, sir. Your sale was subsequent.
Sale deed is 12/8.
Yes, well, it's supposed to be a fraud by the vendor.
On you, yeah, a fraud on you, not on the bank. So you will have to proceed against the builder, sir, against your vendor. We say from the documents placed on record with the counter affidavit of the bank, it appears that the mortgage by way of deposit of title deeds took place on 5th July 2005 itself, whereas the sale deed of the property in favor of the present 3 petitioners was on 3 different dates, namely 12/8/2005, 27/12/2005, and 26th May 2006. All 3 dates are subsequent to the deposit of title deeds with the bank. Full stop. Clearly, therefore, the vendor of the present petitioner has misled the present petitioners into buying a property which already stood mortgaged with the opposite party bank. Full stop. In that view of the matter, the bank was well within its rights to bring the mortgage property to sale for recovery of its dues. Leaving it open to the petitioner to seek appropriate remedies against the vendor. For having been made to part with valuable money for purchase of the property which already stood mortgaged with the bank. The court vacates the interim order passed on 4th October 2010. The writ petition is accordingly dismissed, no order systems.
If the lots will only say disposed of.
Where's the question? Yes.
The dismissal would maybe create hurdles in the
No, we left it open to you that somebody will read the whole order, please. Yes.
Last matter, item number 28.
Who I am appearing for the opposite parties in this case. Yeah. In form of a public interest litigation, my first objection is that it is not maintainable in view of that.
May I submit matters? So that I think I will address first matters that matters senior could get the chance to.
All right.
Let's take Barampur town matters. In Barampur town, number of matters, big ponds are there. In olden times matters since 13 AD matters, number of matters kings and number of jamindars were there. They they constructed these ponds for the purpose of the public. These particular pond matters is a very big pond. It comprises of an area, kind of close to that. It comprises of an area 1 acre 700 to 23 decimal player portion straight. Situated in plot khata number 190, plot number 1679 is some Jalasaya. Very big pond. But what happened? But I am not disputing about the title because a private party is claiming title. I cannot come here for the purpose of the title. The only thing is that the Jalasaya should be retained as it is because it is in the great need of the environmental protection and public. And that is what matters. I have filed this writ application when these Jalasaya, these people must have taking assistance of some gundas and all this wanted to fill it off. To
you have a photograph of how that pond looks now, or
looks now, my lords, I cannot.
This is the photograph. This one also. This is the,
I don't get a chance to see that.
You also see that. And he himself is the purchaser from that land.
No, my lords, that is not the
And he
thing.
is
Just a minute. I am coming to that because if I am a purchaser, I will be also put into trouble. There is no problem in it. There is no problem in it. My humble contention is that in particular, this so far the Jalasaya Kisam is concerned, this should be retained for
see, because we said status quo, this could not even be filled up.
No, we have got a status quo order.
If the photo had been shown to us then, we would have said better fill it up and make it a pond.
I have not gone through that photographs. But the recent I am not aware of what is the position, but there is an interim order.
No, I'm saying the factual position. If you're saying it is a pond, we don't know if it is a pond.
No, it is not maintained as a pond. But a portion of this is being seen.
No, so if it was like this, even on 2011 or whenever we pass a status quo order.
Yes, it's not that much. What is present status? I cannot say with you.
No, look at the kind of interim order you've got. Parties are directed to maintain the existing pond and restrain the persons not to fill up the same.
Yes.
This could mean both ways.
Both ways.
So as a result, this could not be revived as a pond, sir.
I'm coming to that, man. I'm coming to that. Here in this case, my humble contention is this. Milers knows. But I do not know. I think it is a portion of the probably it is one portion of the pond. Because 3-4 years before I had been to Barampur Milers.
See what has happened, sir, if you know how the thing works.
This is not the thing.
No, there's something called aquifers.
Aquifers, yes.
Aquifers.
Well, that is what.
Which should see, there will be streams and subterranean
My-
streams
one of my
through which
theory-
water has to flow.
Yes.
Only the pond can get filled up. All the construction activity around it has obviously blocked the aquifers, sir.
That is correct. But what my humble contention is this, well, here in this case, my lord, the Honorable High Court, our Honorable High Court, taking note of all decisions of Honorable Supreme Court, taking decision of the Madras High Court decision, my lord, division bench decision of Madras High Court, my lords, have come up with a specific, so far Cuttack town is concerned, with a direction to the government to renovate. Well, that is what I am submitting a copy of.
You mean revive ponds?
To revive the pond, because it is in the great need of the environmental protection. That is what I am giving a copy of this. Of course, I was party to that, my lords.
Mr. Rautri, you were appearing for whom?
I am appearing for
Private party, private party.
Owner of the.
I do humbly
owner
submit.
of the land.
Owner of the
Owner of the land.
Well, I do humbly.
And he has purchased a portion
No,
of the
I am
property.
not there, my lords. I am.
He is a encroacher. He has purchased a portion.
I am coming to that, my lords. First, my lords,
And he
let
has
me
not
finish
denied
it. I will
it.
answer that also. I will answer that also.
No, but did you disclose in the main petition that you have purchased?
I have filed a rejoinder and stated that my father.
No, not rejoinder. In the main petition.
Main petition, my lords, I am not at all in the pond.
Sorry?
I am not in the pond at all. I am not encroached. Neither my parents nor myself. This is a pond. What my learned senior submits, that pond has a big embankment. In olden time, I know 100 years or 60 years or 70 years before, my father purchased portion of that particular embankment. Embankment is not a pond. I am concentrating on pond. Well, kind of a glance to further read members of the order of our Honorable High Court, taking note of all decision of Honorable Supreme Court and decision of division bench decision of also Honorable High Court, bench of Madras bench, also Honorable High Court decision of.
For my lordship goes to the merit of the case. I think your lordship must have seen the judgment, recent judgment of division bench judgment so far as the maintainability of the PIL in such cases.
I am coming to that, but I am coming.
That is why I raised that question.
I will satisfy that, my lords. I am not that in the middle, my lords. It will not be difficult, my lords. Very difficult. It will be very difficult to answer. My lords, I am coming to that, my lords. My lords, what happened in this case, my lords? So far, Cuttack is concerned, number of private persons, they were owning from similar situation like that of Madras, because Cuttack was the central of the Fort St. William. It was Barampur was part of Madras presidency, and it was for the Fort St. William. But there also number of ponds were there. What happened? Well, this matter was raised before a Honorable High Court in a PIL. Well, Honorable High Court, in consideration of all these aspects, my lords, kindly have a glance to paragraph 11. The law, my lords, paragraph 11. There, my lords, my Honorable High Court has taken note of the international sphere about the Rio summit and all these things in paragraph, my lords, paragraph 10. Then paragraph 11, my lords, Honorable High Court has explained about the position. So far, the Supreme Court decisions are concerned and the law laid down there. Also, law laid down there in minutes. My humble contention, my prayer is, these ponds should be maintained as a pond like that of, if they want to convert, suppose a private person has a pond, it should be maintained as a pond. But if it is not maintained as a pond and they are trying to convert it to for some other purpose, then my lords, the Honorable High Court laid down a procedure how to be done. But so far Cuttack is concerned, their Honorable High Court also kind of a glance to paragraph 15. Paragraph 15, my lords.
But what is the stand of the state here?
State has not filed any counter, my lords.
Oh, so let us ask.
State, to my knowledge, state framed a scheme. So for Cuttack and given direction to all the districts not to allow conversion of the pond.
Let us ask them, sir, what it is.
My lord, I will draw your lordship's attention to two documents only. That is annexed to the writ petition itself. Annexure 1 may kindly be seen. That is the copy of the Yadast, which is filed by my learned friend. What is the status of this pond? It is written in Orissa. Arsolipita plot, village side ote, ukta plot re gotiye pokhori achi, pokhoriti kaharo jana jau nahi, o eha jala sebana pokhori nuhe. That means the water contained in this pond is not edible. It's not, it cannot be used for any purpose.
Which year was this entry made?
This is of the year certified copy was obtained in 2011. The original must be with my learned friend. But during the course of settlement, during settlement operation, it is noted in the Yadast. This is a very vital noting in the Yadast. There is a pond, but the water body of the pond is not edible. That is first content. Second is my learned friend has filed the record of right, which reveals that the Kisam is Jalasa. What my responsible submission is that my learned friend is correct because he was appearing in that case for Cuttack. There is a scheme has been formulated. It is a land which is recorded in Jalasaya Kasam. If somebody wants to use it for some other purpose, then he has to file an application on section 8A of the OLR Act before the appropriate Tahsildar for conversion. In that case, objection will be invited. Everybody has got right to object before the Tahsildar, and only after the conversion is allowed, the land can be used for any other purpose. That is the common principle of law. So the entertaining a PIL at this stage will amounts to interfering with
No. How did you allow the sales to happen? I mean, under what?
Now, I don't know whether any pond sale can be affected. Your Lordship may kindly see, if I am a purchaser, I want to buy a land which is of Jalasaya Kisam. Nobody can stop me. But being a purchaser, if I want to use the land
No, don't you prohibit sales of such land which has
no, there is,
Jalasaya?
for my knowledge, there is no prohibition. There is no prohibition. But prohibition for change of user. If I want to for a conversion, then you have to apply for under section 8A. I can, if it is a Jalasaya and it is a pond, I want to purchase it, again use it as a pond for my purpose, then there is no bar in it. So my responsible submission is that if the opposite party private opposite party will go for conversion, then it is the right also accrued on the petitioner to object it at the appropriate stage, that it cannot be converted.
One line. You'll also look to paragraph 19 of my counter affidavit. I think in view of that, Learned Friend has nothing to say. That the contention, just 1 minute, the contention raised in paragraph 11 is submitted that no step has been taken as yet, so far as I am concerned, to convert the status of the land in question. So there is no requirement to get any permission from the competent authority. And as and when required, the present deponent will obtain necessary permission. From
that is what I submitted with your Lordship. And in that event, he will have the liberty to object.
I don't have an objection if he says that it will be maintained in this process and follow the due process of law. Nothing more to suggest, except only one prayer.
Yes.
My fact remains, my lords, kind of a glance to this in paragraph 15 of the judgment I have referred to, my lords.
This is the early one.
The judgment I referred to, my lords.
Yes.
My lords, there for the married matters. For the aforesaid purpose, Cuttack city shall be constituted to be before that matters I am submitting matters 8A was taken note of. For the aforesaid purpose, Cuttack city shall be constituted to be the old city, old Cuttack city, comprising of the shown in the satellite map of the such and such. It will be last line matters. It will be open to the state to adopt the direction given in respect of Cuttack city in the foregoing paragraph for other cities of the state.
No, we have not yet. We have not yet formulated for other cities.
That is what I pray. One of my prayer is what government has taken the action. Secondly, my lords, kind of I am referring to 8A. My learned friend submits that yes, it can be subjected to conversion. These conversion miles to section 8A, kind of a
No, he says he
I don't say that.
He can apply.
If he applies, you have every right to object.
Just a minute. I'm coming to that.
So far the 8A is concerned, there is a judgment, just 1 minute, judgment. The OLR Act is applicable to the agricultural lands. So far the urban area is concerned, in Talcher urban area, your Lordship have delivered a judgment. The provision of the OLR Act has no application to the land situated.
So there is no law as on date, my lords. If it is so, what my learned friend submitted, that section 8A applies for conversion, does not apply to that land. So there is no other law to deal with these ponds for conversion.
No, there will be some municipal law, I suppose.
Municipal law means there is no
law is there.
I made
municipalities act.
I made a municipality party, my lords. I made a municipality party, municipal corporation.
No, but there must be a municipal act.
Municipal act means there is no such provision for conversion.
But one thing my learned friend will agree, that for making construction over this land and to get permission from the competent authority under the ODA Act, the owner must come forward with a patta or record of right with Gharabari status.
Which law deals with conversion of usage of land?
Yes.
That
That
is,
should be
as per
clarified.
my knowledge.
See, in other cities, like you have a Delhi Development Authority Act.
Yes.
You have a
There
Bangalore
Barampur
Development.
Development Authority, Barampur Development Authority is there.
No, Barampur Development Authority is there. Odisha Development Authority acceptance.
That
With
ODA
our-
Act is applicable.
and
Odisha
with our
Development
other
Authority
provision
Act
of law,
1982.
So far conversion is concerned, that has taken a different dimension. But so far 8A is concerned, Whaler Act is concerned, is not applicable.
No. We are on this Development Authority. Is there a
Development Authority has
Barampur?
accepted this
Is there a Barampur Development Authority?
Yes, my lord.
There is a Barampur Development
So
Authority.
is it a statutory body?
It is a statutory body once under the
Ah,
Development Authority.
So
Act.
why don't you
ODA
look at the manual? You get the Barampur Development Authority Act.
No,
ODA
there
Act,
is
my
no
lord,
such-
Odisha
there is no such
Development
Barampur
Authority
Development Authority Act. It is Development Authority Act. Under the Development Authority Act, Barampur Development Authority Act been constituted.
No. So
Development
that must
Authority
be
Act-
dealing with change of land user.
Change of land use manuals, that is because they say that change of land use in accordance with this OLR Act. And only they have to give a permission. That kind of a glance to section 8A of the OLR Act. They say in case of a conversion, the development authority, they have to take permission from the development authority.
Yes.
Now my learned friend says section 8(1) in respect of is limited to only agricultural land, not in respect of the pond. That is what there is a gap. That is why I included the municipal corporation so that they will come forward and say that whether they have a
I think you
provision.
make your stand clear then. Nobody's appearing for the Barampur Municipal Corporation.
I think nobody is appearing, I think.
If there would be a stand,
My lord, in
there
any
Alright.
case,
is an authority.
The
who will
present
deal with
public
this.
interest litigation is concerned over a area of land admeasuring 1 acre and
1 acre. Well, 1 acre, 723 decimal.
known as single quotes Desh Behera Bandha, located in Khata number 190, plot number 1679, ward number 5 of Barampur city. The case of the petitioner is that the land is categorized as Kisam Jalasaya, but steps are not being taken to maintain it as a single quotes pond. Full stop. Directions were accordingly sought to the opposite parties, 1 to 4, to maintain the pond in the greater interest of the petitioners and the public at large. Full stop. Paragraph. As it transpires, opposite party number 5 is the actual owner of the said plot.
He claims to be the owner, manners.
Sorry?
He claims to be the owner. I don't dispute. I don't dispute. He claims to be the
according
owner.
to your record of right, he is the owner.
A record of right, yes.
Annexure 2.
Opposite party number 5 has filed an affidavit in which inter alia in para
19 minutes.
19, he has stated as under. Reproduce para 19 paragraph. While entertaining the present petition on 24th March 2011, the opposite parties were directed by this court, open quotation, to maintain the existing pond and restrain the persons not to fill up the same until further orders, unquote. Today, when the case was heard, photographs were produced by Mr. Buddhadev Rautre, learned senior counsel appearing for opposite party number 5, of the land in question, of the plot in question, which shows that it is a vacant plot of land with some vegetation, but certainly not having any water whatsoever. Full stop. In other words, there is nothing to indicate that it is a pond. Full stop. Paragraph. Although opposite party number 5 has stated that as and when he seeks change of the status from Kisam Jalasaya to any other form of use, he will seek the necessary permissions. It is not clear under which municipal law the opposite party number 5 would have to apply for permission. Full stop. On the specific aspect, the court would like to have the views of the Baharampur Municipal Corporation, which is opposite party number you've deleted it. That's the whole problem. Originally, you had implemented them as
Yes.
opposite party number 5, then it was deleted. I don't know why.
Deleted
By 24/3/2011.
because he must be the lawyer for this. I'm not aware of matters, so I will file a petition to implement them. ଆପଣ BMC ର ଓକିଲ ନୁହନ୍ତି ତ? No, I'm not. No, I'm not the lawyer.
Full stop, bracket BMC, you say, although the BMC was deleted under order dated 24th March 2011 of this court, it appears that it is necessary to have its views in the matter. Accordingly, BMC is again implemented as opposite party number 6. Notice is directed to issue to the BMC to file returnable on 19 July 2022, by which date it will file an affidavit indicating its stand, clearly its stand in the matter.
Interim order to continue.
Interim order to continue.
My lord, case will be listed on
19 July.
19 July.
Supplementary. Take it up now or we'll take it up. Yeah, we'll take it up.
Supplementary list.
item 1.
Fresh admission item number 1.
Sir, become infructuous, my lord.
None appears to the petitioner. Counsel learned AGA informs the court that the petition has become infructuous. It is disposed of as such.
Supplementary list item number 2.
None appears dismissal, non-prosecution.
Supplementary list item number 3.
Item number 3, my lords, I have no instruction in the matter.
No instructions, disposed of as such.
Supplementary list item number 4.
And I pray for next week, my lord.
No, tell us what the matter is. What is the matter about, sir? Tell us. Contractual appointment rules.
All these petitioners were appointed under that rules. Now, for completion of more than 6 years, now they are challenging the selection rule. And that is not permissible. I am placing one judgment.
My lord, in this case, Mr. Jaswant Singh has been engaged. He could not be instructed, my lord. So I want for adjournment.
Pleadings are complete, Mr. Mudli?
No, notice has not been issued.
Oh, notice has not even been issued. Oh.
No.
Although the matter has been adjourned twice, a further adjournment is sought on behalf of Mr. Jaswant Das, learned senior counsel, who according to your Mr. Siddeshwar Malik.
No, my lord, PC Das.
Mr. Das, advocate for petitioners, has been engaged to appear in the matter. As a last opportunity, list on 17th May.
Supplementary list item number 5.
Well, item 5, my lord. Petitioner is trading of all kinds of fruits, my lord. Almost small wholesale and retail basis of fruit businessman, my lord.
Can't hear you, sir. You have to be louder.
My lord, assessment year 14 and 15, my lord, is filed return, my lord, income tax file, my lord, on 22nd September 2015, my lord. But after 6 years, on 31st March 21, my lord, is a notice on under section of 48, my lord. Is a time bad matter, my lord.
Let me listed on 11th July, my lord.
Sorry, or
11th July.
11 July. All right. Notice, Mr. Chimanka accepts notice. reply if any be filed within 4 weeks, rejoined for the next date.
Extra copy may also given.
All right. No coercive action shall be taken against the petitioner till the next date. List on 11 July.
Extra copy may kindly given.
Yeah, that will be part of the order. Extra copies be served.
Supplementary list. Supplementary list.
Yes,
item
yes,
number
both
6.
matters.
Similar matter, second case, my lord.
Item number 6.
None appears dismissed, non-prosecution.
Supplementary list item number 7.
For item 7, I am there. But if your lordship remembers, I filed additional affidavit for condonation of delay in filing the review application. Well, there's a very short point actually review is sought for. That point is with regard to consider the authority to consider the recognition with effect from 85-86. Though there were documents, the Honorable Single Judge could not notice the same and passed an order that it should be recognized, and recognition has been granted with effect from 2002 and 3. So that is the only point involved. If your authority can consider it again, that will be the only prayer.
Let's see that order under review, sir. That will give us an idea.
For a review, actually,
What is the delayed number of days delay, sir?
135 days. The former secretary of the college, actually, he expired. And the subsequent person actually who came, he came to know about the order and they immediately filed an application. And COVID intervened in the matter and thereafter he filed it. An additional affidavit has been filed to justify the delay also. Only point to consider, nothing else, my lord. No other point is involved, no legal point is involved.
So what is that to show the college was in existence in 85-86?
The document R1, if you lordship kindly see, and 3 other documents are there. Those were filed, my lord. Those documents show that in fact college students were admitted, but they cannot appear in the college which do not have the recognition. Therefore, they have to be adjusted with another college.
Right.
Though it is said that since they were not in their name, therefore it cannot be done. That's not the law. Law is that if you have admitted and permission has been granted subsequently, it has to go back to the relevant year itself when the admission was taking place. Because my application for permission was pending at that time. That's the only thing to be considered because those staff and other things they have been engaged and appointed.
No, but does this college exist now?
Yes, Merit, it exists, Merit. Now it exists, Merit is continuing with the permission with effect from 2002 and 3.
No, but what was the prayer before the single judge and what was granted and for which you went in appeal?
If you kindly see the Honorable Single Judge order, page 57.
The writ petition was dismissed.
Yes.
What was the prayer in the writ petition?
Referring to that order, Single Judge order. Honorable Single Judge, in last paragraph of the judgment, has specifically indicated there is no dispute the extent the permission has been accorded for session 2002 and 3, but the petitioner pursued his grievance that the institution should be granted permission with retrospective effect from 85-86. But no material has been produced before the court to extend, but it has been there. 3 documents were filed to show that students were allowed to appear in examination in another college because the recognition had not been granted at the relevant time, though prosecuted. That is the reason why the court said that it is from 2001 and 2, not before that.
So the question of retrospective permission doesn't arise, sir. And not in 2000. See, what you're saying is you should now grant me permission to run the course from 1985-86 onwards. And you're making this prayer in 2017, sir.
The claim is not retrospective. Claim is not retrospective. The word has been used retrospective. If your lordship looks at page 24 of the read brief,
yes,
Annexure 3.
Yes.
Bill page 30, Annexure 3.
Page?
Page 30, my lord. Annexure 3.
Yes.
This is a letter to the Secretary, Kamalarjuna Mahavidyalaya, dated, if your lordship looks at 8/1/86. I am directed to request you to kindly furnish the report on the following points for taking further action. The application was pending. It is not that I want retrospective, right? My application was existing at the time. All inquiries and
No, but you came to the court only in 2010, sir.
yes, he came.
What? So what were you doing all those years?
No, he filed an application. Then Honorable Court directed to file for an appeal for the appropriate authority for the education tribunal. Filed an appeal. Then disposal of that kept pending. Then another writ application was filed for disposal of the same. So all this time litigation is going on, not with regard to the merit which has been decided. Now, for the first time, it has been decided on merit by the Honorable Single Judge, who said that 2001 and 2 recognition is correct, not it cannot be granted retrospective. In fact, there is no prayer for retrospective. There was no prayer for retrospective permission.
But no notice was issued. You say the delay in filing the appeal is condoned. This court has heard submissions of Mr. S.P. Mishra and its senior counsel appearing for the appellate. A review sought of the order dated 5th November 2019, by which writ appeal number 264 of 2017, filed by the present appellant, was dismissed in limine by the court. Stop. The said appeal was a challenge to an order dated 15 July 2017, passed by the learned single judge in writ petition civil 9449 of 2017, paragraph. The prayer in the writ petition
At page 24.
24, is it?
Yes, sir, 24.
was for according permission to the college of the petitioner from the session 1985-86. And to quash a decision of the High Power Committee rejecting the proposal of the appellate college for recognition of its +2 arts wing. Paragraph. The learned single judge appears to have proceeded on the basis that the appellant was seeking approval with retrospective effect from 1985-86, and then observed that nothing was placed on record to show that the college was in existence as of that date. Full stop. In the order and review, the division bench appears to have proceeded on the same basis, namely that there was no document to show that the college existed as of 1985-86. Paragraph. Mr. Mishra has drawn attention of the court to a letter dated 8/1/1986. Which page was that?
Page 30, my lord, 30.
Written by the Directorate of Higher Education to the college, raising queries in regard to its letter dated 18 September 1985. Paragraph. It does appear that despite the above document being part of the record, it was not taken note of by the division bench while dismissing the appeal. This being an error apparent to the face of the record, the order dated 5th November 2019 passed by the division bench, dismissing WA number 264 of 2017 is hereby recalled, and the writ appeal is restored to file. The main writ appeal say this will have to go before the roster bench. List before the roster bench. All 12th May 2022.
Supplementary list item number 8.
For restoration, my. I have for restoration of the.
Tell us what the writ petition is about, sir.
I have challenged my lord, the petitioner challenged the rejection of his candidature for appointment under rehabilitation assistance rule as per the new
I
rule.
see. All right. For the reason stated, the petition is, the application is allowed, and the order dated 15th February 2022, dismissing WP Civil 30795/2021 for non-prosecution is hereby recalled. Then in WP Civil 30795/2021, you say notice Mr. Mudali accepts notice on behalf of the opposite parties. Mr. Mudali, this case law seems to be changing now. Every other day you have another judgment of the Supreme Court taking a different view.
But but the N. Santosh Kumar remains the same.
I know, but subsequent judgments have all explained Santosh Kumar. I think one of them is a 3-judge bench order also in an SLP. We'll have to do a lot of reconciling now. Because after we took that view, there were 2 more judgments taking a different view in the Supreme Court. So in one of the matters, I've in fact allowed the review and I've placed it again before the roster bench. Replies be filed within 8 weeks, rejoinder for the next week. List on 29th August.
I will file 3 extra copy to State
Yes,
Council.
all right.
Okay.
Supplementary list item number 10.
I humbly pray, my lord, this matter may be taken up along with 91 WPC number 9121 of 2022, my lord.
It's listed today?
No.
When is that listed?
That's been taken up for tomorrow or day after.
No, when is that listed? That's not yet listed.
No, not yet listed.
Oh, I see.
Not yet listed.
List with writ petition civil
21/2022.
9121 of 2022.
Yeah.
27th April.
Item 11.
Infructuous.
Item 11, infructuous. It's disposed of as such.
I am appealing.
All right.
Item number 12.
May I please, madam. Now the petitioner files his application for the limited prayer of the petitioners to for arrangement a passage southern side of railway line, madam. The petitioners are poor cultivators. Rest of their land were western side of railway line, my lord. They made grievance petition before opposite parties.
All right. The petitioner's representations dated 13/12/2021 will be examined by the
UP number 3, your lordship, my director.
Managing Director Anugul Duburi Sukinda, New BG Railway. Opposite party number 3. And after giving the petitioners and after issuing notice to the petitioner and giving him a hearing, will he be able to go for the hearing? He's 70-year-old man.
Yes, my lord. Yes, my lord.
Or a reasoned order should be passed thereon not later than 1st July 2022 and be communicated to the petitioner not later than 8th July 2022. The court clarifies it has not expressed any view in the matter.
Supplementary list item number 13.
But here, considering the applications made by the villagers, the under annexure 1, the secretary directed all collectors to inquire the matter and for customers 3 that is the mini stadium in 3 village, the 3 blocks of the Srijang, that Khantapara and Remunam block.
No,
accordingly, annexure 4, page 13 block, 13 lakhs was sanctioned for construction mini stadium in the
Anyway, your presentation is that the petitioner's representation dated 1/1/2022 shall be examined by the collector.
Yes, by the collector.
Baleshwar bracket opposite party number 2. And after issuing notice to the petitioner and
Plus 7 and
giving
8.
its representative a hearing.
Plus 7, annexure 7 and 8.
The reasoned order should be passed not later than 1st June 2022 and be communicated to the petitioners not later than 8th June 2022.
Annexure 7 and 8, that is there the letter of the department block, that is a sanction of the rest amount. 50% they are sanctioned, other 50% they are pending.
Anyway,
annexure 7 and 8 block.
the court clarifies that it does not express any view of the matter.
Yes.
Supplementary list item number 14.
I filed a date check.
Where is that? Yes.
23rd August 1986, madam. The petitioner was appointed to the post of junior grade typist under rehabilitation assistance scheme. On 30th 4/887, she faced a termination on account of reduction in the establishment. Then 87, 22nd May 2008, 1987, appointment to the post of junior clerk, 90 Malod. Regularize the services period by condoning the period of termination, because termination was due to the non-ability of the post and reduction in establishment. That was condoned. Then your lordship can see 22nd March 91, appointed as junior grade typist, junior most among the junior typists at headquarters directorate. So I was placed because before that I was not in regular service. In 91, I was treated as I will be in the lowest in the gradation list. Then allowed 92. She was allowed to drop the scale of pay. 95. Transfer to district office as well as Khurda. That was challenged tribunal said that since it is a nearby place, you go there. Then 95, Lordship can return to 4/12/95. That transfer application was disposed of. Then Lordship can see 20th/9/97. Data Assembly is published for ministerial employees of Headquarter Directorate of Economics and Statistics. Then, my lord, 14/7/88, the petitioner protested as her name did not find place in the Data Assembly list. Submitted representation before the government. Then 30th/12/2001, my lord, government rectified the mistake and the Data Assembly list of 97 has been modified by maintaining seniority position of the petitioner from 91, which was given in the 91 Annexure 3. I mean, indulge your lordship's attendance some of the annexures. And so far, the individual opposite parties are concerned, they were appointed after 13 years of service of the petitioner in the year 99. Let's see, can it count to Annexure 3? Annexure 3 is the condonation, not Annexure 4, page 20. She has been, I mean, permitted down. Annexure 4, page 20.
Yes.
She has been selected for appointment to the post of junior grade typist under Directorate, or the look at it, Directorate of Economics and Statistics, Orissa, such and such pay scale, with usual as sanctioned by government from time to time on our own request. The appointment is purely temporary and can be terminated. Then second matter.
Mr. Mishra, who's appearing for those opposite parties, individuals who had succeeded before the OAT?
I do not know.
It's important to hear them, no?
That's true.
Because it's an interstate dispute.
So my contention is I was appointed 86. They were appointed 99.
No. What is it? What is the service position? What's the service position as far as they are concerned?
Vishwajit Mahathi 3. Vishwajit Mahathi 3.
Vishwajit Mahathi 3.
School and master.
Some of them is
Yeah, I am for the opposite party number 3 for 5, my lord.
Okay.
All right.
Applicant in the tribunal, ma'am.
Right.
Then you lordship can turn to Annexure 4, page 20.
Yes.
Second paragraph.
Yes.
The appointment is subject to the condition that she would be junior most among the junior typists at the headquarters of Directorate of Economics and Statistics, Orissa. This is on 22nd March 91. So I was brought to the cadre of the head of the department with effect from 22nd March 91. Then man on Annexure 5 is the regular scale of the granted malon.
No. By which time these three were already there?
No. They were entered in 99. I was entered 86. 91 edition was rendered that I should be below the reduction list of junior typist. That was in Annexure 3, my lord. That is 22nd March 91. They were not in the cadre. They were entered in the 99.
All right.
My lord. Then the question arises, my lord, the impugned order, or second turn to the impugned order, Annexure 11. I mean, sorry, my lord. Annexure 12, page 49.
No, that's Annexure 11 only. 18/12/2006.
Yes, sir. 18/12/2006.
Right.
Page 49.
Annexure 12.
The tribunal has said that since he was again transferred to a district office, he cannot claim the seniority, or the government would rectify the mistake and placed him seniority from 91 cannot be sustainable. That is the plea of the tribunal, and it is an admitted fact that we can look at.
So the argument is that you do not belong to the same cadre as those three.
Yes, my lord. In the year 99, because again I was transferred from that cadre to district cadre. Again come back, my lord, to the cadre. They say the proposition of law is that he will
come to page 53.
Yes, ma'am.
I think it starts from the bottom of 52.
53, 52 Malord.
Yes.
These facts are admitted. I'm reading out paragraph 4.
Yes.
The question arose as to whether respondent 4 can still match over the applicant in the gradation list as on 31st 1296. We are surprised to find that if respondent 4 was at all in the district DSC headquarters, then a name for the region best known to the respondent was not reflected in the gradation list as on 31st 1296. Lord and counsel for the applicant respondent 4 both clarified that this was a mistake because the applicant had already been transferred out in 95 from directorate to DSO Khurda. But the Lord and counsel for the respondent 4 was quick to refer to annexure D4 to his counter issued on 31st 12/2001, placing respondent 4 at serial number 8A below Obira Mahapatra, appearing at serial number 8 on the gradation list as stood on 31st 12/2001. If we treat this D4 communication to allowing respondent 4 a place in the director gradation list, then fact still remains that she should lose her status in the gradation list by virtue of transfer to Khurda, where she continued from 97 to 2002.
It will be a fresh encardament, inasmuch she had lost the link with the cadre.
Link to the cadre. That is the plea they have advanced. But
Yes.
admittedly, I was given to the cadre in 91. Then, my lord, it was their prerogative to transfer me to somewhere other place. But I cannot lose the cadre. Once somebody appointed a cadre, he cannot lose the cadre unless Leon is gone, or otherwise is transferred, or by own request have transferred. They transferred themselves from the headquarters to district offices. And lordship can look at annexure 3. It was clearly given once I was appointed, I was placed below, just entirely below the gradation list of junior clerk. That will March 91. Then they transferred me to district cadre. And thereby say, once he is transferred, again he returned back to 2002, he cannot get back his seniority from 91. And they were entered in 99 service, after 13 years of my service.
Or let's hear Mr. Ramakant Das. You have to unmute, sir.
Yes, sir. See, and the matter is that the question as tribunal has decided whether the corrigendum can replace the present petitioner from 1986, where she was appointed against the cadre posts. There was no cadre at all. She was never appointed against any cadre. But in the year 1994, when 95, she was transferred to Khurda, district cadre postman. When he was
But that's not her choice, is it? She's not asking for a transfer. She is being transferred.
Because by the
How can it be to her disadvantage, sir? How can that be to her disadvantage?
Yes, my lord. By the
I can understand if she voluntarily sought a transfer and left one cadre and joined some other cadre. That's not the case.
No, my lord. By the order of the Honorable Tribunal, the petitioner in the order of transfer, he was accommodated because the regular post has been made against the other applicants, my lord. By the virtue of the order of the tribunal, the present petitioner has been transferred to the Khurda, my lord. Only to accommodate, because they are regular posting by the order of the Honorable Tribunal. Then after the petitioner was transferred to the Khurda DSO. When he was continued, then he come to in the year 1991 to the 91 to the 2001 to the cadre, my lord, director cadre in 2001, for which tribunal hold that she was come to the cadre on 9/1/2002 only.
No, that is what is being questioned, sir.
Yes.
That is what is being questioned. Whether that can be the date when it can be said that she entered the cadre, or when she was already there in 1991.
No, my lord, nowhere she was in cadre, man.
No. There is a letter, sir. What are you saying? It's just now read out by Mr. Mishra. She is placed at the bottom of that, as a junior stenographer. She's at the bottom of the list.
Yes, my lord. But later on, his name, her name has been incorporated in the gradation list, my lord, by virtue of the corrigendum. She was never in the gradation list, my lord, earlier.
No, no, that is not her fault again, sir.
Yes, my lord. Because she was never in the cadre, my lord. She was never in the cadre. How can she come to the cadre in 91, my lord?
So it's not a question of some resigning and going away or anything like that. It's only transferred to another district
Yes, my
location.
Lordship say proposition, my lord, because she was never in the cadre. In the S cadre, she was continuing.
No, no, everybody has to be in some cadre, sir. Please. It's a regular appointment as a junior stenographer. There's no question of not being in a cadre.
My lord, kindly have a glance to the order of the annexer 6, my lord, page 22. 22, pursuant to the department letter, so and letter so Haramani Das, junior clerk, along with continue escadre post, junior clerk, junior grade typist, created the scheme VICS, Headquarter Directorate of Economics and Statistics, Orissa, until further order. Against the Haramani Das, CU has been posted, my lord. The present petitioner, ex-cadre post, my lord. Clearly stated.
These are all not matters of choice. She'll be given a posting order. She has to go and report wherever she's posted. Where is the choice?
As she was under rehabilitation assistance scheme,
That is completely beside the point, sir. That's not the point at all.
In fact, your lordship, in paragraph 6 of the counter affidavit, we have stated that in compliance of an order passed by the land tribunal in another way.
Therefore,
the petitioner has to be transferred from outside the cadre.
So that doesn't mean she loses her seniorities. So we'll reverse the order of the OAT, sir. We'll allowing the petition. Petitions allowed.
Supplementary item number 15.
On item 15, I am appearing for it. The order subject matter of challenge at page 37. Last occasion, if your lordship, after looking into the order itself, your lordship was asking me a question actually whether all these persons are beyond the age.
Yes.
And there is no point in passing an order for reinstatement or appointment in regulation. Because nobody is there in service since 2000. But they have not filed an affidavit that they have not been gainfully employed anywhere else. But if your lordship looks at the application itself, with due respect, it is misconceived because they themselves, this Sangha has come into picture, not individuals. The REIT applications were filed in 96. Honorable Court directed that you should approach the education authority. Then the matter was referred to and the conciliation failed. After the conciliation failed, out of the Sangha tried to project 80 persons, out of whom 43 were shortlisted. But out of those 43, actually, if you also look at their work worker, fire guard, pump operator, then electricians, wireman, electrical helper, but there is no permanent post in the IDCO itself. IDCO itself is a project. It works in different areas for development of industrial units, and they give it lands and other things by acquiring as per the IDCO Act. It doesn't have any permanent post, substantive post. But this direction itself, because they were engaged by different contractors at relevant time, and they were discharging their duties. It's true that IDCO provided them the facilities like the ESI benefit and other things. That doesn't mean IDCO directly have control over the workers. So they were all temporary workers, project-wise work. After completion of the project, their work gets terminated or completed. Now, the order that is at page 37, if your lordship looks at, 43 claimants whose names are noted in para 9 of this award, who are working as casual dealer workers in establishment of the management, are entitled to regularization in their service. In that context, the management to take steps to absorb them in phased manner within 6 months, hence in adopting the same norms as it had followed in respect of persons named Exhibit 1. As regards the benefit of equal pay for equal work is concerned, no direction is felt appropriate in this in view of the finding of the tribunal in the matter of regularization of the claimant in regular establishment of the corporation. That was the order. Now, about 40 years have passed in the meantime. So they claim to have engaged in 1996, 20 years prior to that. 96 till today, it has now 26 years. And no age has been given to any of the individuals. The individual never came to picture.
No, somebody is appearing for them. Yes.
Last
How many of
time-
these workers are at an employable age, sir?
At present, my lord, at the time of engagement.
At present, sir.
At present, my lord, they are within the age, my lord, that is, as per my read petition, my lord. I file affidavit to that in that regard, since the union was contesting my lord, the case, my lord, and no specific age is there.
No, let's see the award, sir. Claim statement in the award will tell us.
My lord.
Award is 30th March 2010. Correct?
30th March 2010.
So there must be a claim statement in that.
No claim statement.
Where is the award copy, sir?
Award copy is Annexure 3, Madam.
Annexure 3, page 25.
So General Secretary Shramak Sangha.
Yes.
80 casual. No, the 80 casual workers.
80
So what are the ages of these 80 people, sir?
Well, out of 80, my lord, a quote below, my lord, already held that 43 casual laborers are the workers engaged by the management, my lord.
So what is the ages of those 43, sir?
Age 43, that has not been mentioned here, my lord.
We're asking you, sir.
Yes, my lord.
You have to answer that. What is the age of each of these 43 persons?
In that regard, I will file affidavit, my lord. Since that has not been disclosed anywhere, my lord. But they are the workers working.
Where are they right now located?
No, my lord.
Where are they located, sir? These 43 workers?
They are located in the different office of the IDCO, my lord. Management.
Even though they may be 75 years old, 80 years old, they will be located in IDCO.
They are within the age, my lord. They are within.
How do you know, sir? Have you found out? You are not able to.
Yes, ma'am. I'll find out. I'll find out. My lord, I'll file.
Are you saying I will find out? Are you have found out?
Yes.
Both you're saying yes.
I will find out. I'll find out.
All right. Counsel appearing for the workman states that he will ascertain how many of the 43 workmen who were beneficiaries under the impugned award of the Labour Court are of an employable age as of today and where their present location is. He states that he will file an affidavit in this regard before the next date. List on 29th June. Break bench. All right. Okay. We'll continue after lunch.
She coming here?
IA has been filed for interim bail on accounts of the petitioner's first death anniversary.
Right,
Which is going to be held on 16, Your Lordship.
Is that correct?
Yes, yes, I have obtained instruction.
All right,
There are 3 sisters and only one son.
all right. The Mr. Katke, learned AGA, has obtained instructions confirming that the petitioner, the applicant, is the only son of his parents, and the father's death anniversary is going to be held on 16th April 2022. In that view of the matter, the petitioner is directed to, the applicant is directed to be released on interim bail for a period of 2 weeks from the date of his release, subject to the satisfaction of the trial.
May I pray? Mother is old, ailing.
It's all right.
Your Lordship.
The anniversary 2 weeks. is enough.
As Your Lordship. And I pray in course of the day, because the 14
Yeah,
and
we'll
15
sign
are
the order.
holiday.
You'll get the order today.
Yes, my lord. Oblige.
The surrender certificate be placed in record. Right.
List item number 16.
None appears. Dismissed for non-obstruction.
Supplementary list item number 17.
None appears. Dismissed for non-obstruction.
Supplementary list item number 18.
On behalf of Ms. Priya Das, She hasn't received the counter affidavit yet, Your Lordships.
No, but what's the matter about?
Sir, I have no further instructions, Your
No.
Lordships.
Let's just find
I'm
out what.
appearing on behalf of Priya Das.
Reinstate the petitioner. This was filed way back in 2019.
He was a candidate peon. He was a
Candidate peon,
peon.
so that will not, there's no question of candidate peon getting reinstated. You see, the system of candidate peons having been discontinued.
He was only impaneled and thereafter removed from the impanelment.
The question of the reinstatement of the petitioner as candidate peon does not arise. Consequently, the order dated 10th October 2014 disempaneling the petitioner as candidate peon calls for no interference. The petition is accordingly dismissed.
Supplementary list item number 19.
My lord. This PIL is filed by the affected farmers due to damage of their water reservoir. The dispute is that there was a water reservoir which was damaged during the construction of nearby road and bridge. There is a natural stream of flowing of water in that is the rain-fed water, which was stored in a water reservoir, and that water reservoir was providing water to thousands acre of land. But in the year 2016 and 17, the RD department constructed a bridge and road near the water reservoir, and during such construction, they destroyed the water reservoir, the wall of the water reservoir. Therefore, public resentment was there, and the affected farmers filed their representation, several representation under Annexure 9 is one of the annex representation.
Let's see the counter affidavit, sir.
Counter affidavit has been filed. I have also filed my rejoinder.
So let us see the counter affidavit.
Yes. In counter,
para 7, let's read.
Para
it.
7.
Paras. Para 7, madam. Para. In para 7, the annexure C by 4 and D by 4 has been referred. Kindly take a glance to page 4.
So kindly read para 7.
Para 7. That with regard to the amendment made in paragraph 2 of the writ petition, it is submitted that Ghagara Nala flows across RD road, Santhapur to Madhapur, Marthapur at
Chennai
1.57 kilometer. This road has been damaged severely during cyclone Hailen in the year 2013. Government of India has upgraded the aforesaid RD road in the year 2016-17 under Pradhan Mantri Grama Sadak Yojana, and the sanction fund by the package number OR 09116. After following the
due codal
procedure, tender was awarded to L1 bidder, namely Sri Dilip Kumar Sahu, a class contractor. Cost of package was 189.97 lakh. Date of commencement of work and date of completion of work fixed at 18/10/2016 and 17/9/2017 respectively. Tender work package number OR 09116 has been completed on 31st 5/2018. As per the project report,
one box culvert of size 2 span and 6 m into 3 m has been constructed. The existing narrow vented causeway was dilapidated condition having 2 into 1 m into 0.9 m vent area. It was seriously damaged during polythene. Such condition of vented causeway had been causing danger to the life and traffic during peak flow of water. People of that area were facing difficulties during rainy season. Considering the above difficulties, Government of India in NRRDA, while preparing project report, had approved construction of 6 into 6 m into 3 m box culvert in place of dilapidated vented causeway. After construction of box culvert, the people of Santapur requested to construct one concrete wall downstream of Nala having 1 feet 6 inch height and with one opening gate in their village side so as to divert water flow to the lean flow period. Copy of request letter of Santapur villagers is annexed herewith as annexure A/4. On the basis of representation, grievance of the villagers was examined by the site engineer. After field verification, said engineer found that 1 feet 6 inch wall is required to protect the box culvert. Accordingly, one concrete wall having 1 feet 6 inch high with opening to the village side has been constructed 10 inch downstream of the newly constructed box culvert. Such construction was beyond the scope of the agreement and the same is included in the final deviation statement of the work. Copy of the photograph of concrete wall is annexed herewith as annexure B/4. Admittedly, construction of a concrete wall having 1 inch 1 feet.
So there is a fight between two sets of villagers.
Yes, my lord.
Yes, my lord. Kindly take a glance to the statements.
And there was an agreement between them by Exhibit C/4. According to their agreement and consent of both the villagers, this work was already completed since 2018 during pendency of the writ petition. There is no more to be.
Because in the annexure C/4 agreement, both the villagers agreed in presence of the authority.
So let them enforce that agreement, sir.
Yes, to rise the height of the wall. That is the agreement. It has not been complied
because you filed the PIL.
No, my lord. Because of they did not comply this agreement.
No. Agreement is of 2018. Please see.
Kindly take a glance to what is the date of that agreement. The date of agreement is 13 July 2017.
But there is something else.
Thereafter, I filed the representation under Annexure 9. We filed the Annexure 9 representation on 27/7/2017. Just 15 days thereafter. Only because the authority did not give any importance to this solution and did not rise the height of the reservoir wall. Therefore, the writ was filed because more than 300 farmers are affected.
My lord, my
Annexure 9 representation is there. It's pending before the authority.
My responsible submission is that there was an agreement and both parties agreed that this work should be done in a particular manner. Thereafter, we completed the work. Now he is saying that in accordance with the agreement, the work has not been done. Your lords may kindly look to the prayer. He has not come to this court to enforce that agreement. He has said that should be demolished or replaced, something like that. If the agreement has not been complied, then he has the course open for him to approach the appropriate authority to enforce the agreement.
So I'll record the fact that you want the agreement to be complied with.
Yes, kindly take a glance to my prayer. What is the prayer of these affected farmers? Farmers, the prayer is issue notice to the OPs and after hearing issue the writ of mandamus or any other writ against the opposite party, direct to them to restore the original position of the
Yes.
stone bed of the natural
That
water
is not
stone?
possible. That is not
Can- can-
possible. And
can you take a
agreement,
glance?
so far as this part of agreement is concerned, he has
I was
considered.
allowed to present,
He has-
present the prayer books. Original position of the stone bed of the natural water stream and the wall of the reservoir up to 3 feet height within stipulated period fixed by the honorable court, and also direct the authorities to dispose of the representation under annexure 7 and 9 and raise the height of the concrete wall of the water reservoir up to 3 feet height on the old site and make arrangement for free flow of water to the agricultural land of the village Santapur. That is annexure 9. We have made the representation saying that
It's not practical, sir. These
Practically-
prayers are not practical at all.
because my application.
We are prepared to record your statement that you want the agreement dated 13 July 2017 to be implemented. We'll record that and we can dispose of it.
Yes, by,
And that-
in my
That
region,
your lordship can do, but my respectful submission is that he has not disclosed it. We have filed it in
I
our
know,
counter
I
affidavit.
know.
They have not said that there
Yeah.
was an agreement. They have concealed it.
Yeah. Council, the petitioner
Can-
states
can-
that
my region is there.
the petitioners who all belong to village Santapur are satisfied will be satisfied if the agreement dated 13 July 2017 entered into between the villagers
Villagers of Santapur, then villagers of
no, Kabera and
Kabera.
Madhapur on the one hand and Santapur on the other is implemented. The said agreement has been enclosed as Annexure C4 to the counter affidavit filed on behalf of opposite parties 1 to 4. Full stop. It was entered into in the presence of the IIC Gondia and the engineers of the R&D department. Full stop. In that view of the matter, a direction is issued that the terms agreed between the parties as specified in the agreement dated 13 July 2017 be given effect to by the local administration with the least possible inconvenience and at the earliest possible and in the earliest possible time frame. No further directions are called for the petition's disposal.
Supplementary list item number
target, my lord, target the period so that the farmers will be benefited and the matter target.
What is that? I don't understand.
Time limit, my lord.
No, earliest possible, sir. We don't know how long. All right.
item number 20.
Item 20,
Please,
compliance of order dated
Let-
22/11/2021. Now, though I have filed a compliance affidavit, but today while I was verifying the compliance affidavit along with the counter affidavit, I found some certain discrepancies. So Lordship, I pray your Lordship may call this matter next week so that I can clarify the situation.
All right. Mr. Mudli states that there are some discrepancies in the affidavits already filed and he wishes to clarify the position. Stop. He accordingly prays for an adjournment. List on
Next week, any day? Because my lords have already heard the matter.
I know. 17th May only, sir. 17th May.
Supplementary list item 21.
You have already signed the counters. Hey, we try and
Okay. Rejoinder will be filed for the next date. 17th August.
Supplementary list item 22.
This is regarding that PET CT scan to be installed at the Acharya Harrier Cancer Institute along
Correct,
with
sir.
this is my lord.
Correct.
The last time the council for the Acharya Institute, Harrier Institute had said by April, by end of March, they should be able to complete the project. The CT should be installed. So I do
Right.
not have question as to whether the project has been completed by now or not, my lord.
There also the signed affidavit that they will complete by October 2021. And thereafter, they also filed an affidavit that they will complete it by March 2022. That is their affidavit filed by document number 3.
a committee consisting of 17 members has been constituted on 14th, 7 members on 14th
Yes, that-
February.
That period we have mentioned in our affidavit. What you may kindly see the last order, the 3-page, 3-paragraph order was passed, but with regard to state government, my lord, para 2 was important. I'll place that. As regard, this is order dated, my lord, 11/11/2021. I've quoted in para 2, page 2 of my affidavit, my lord.
Yes.
My lord, as regard installation of similar equipments at Baleswar and Berhampur, Mr. L. Samantha, learned counsel for the state government, informs the court that the feasibility study in that regard was unable to be undertaken by AIMS at Bhubaneswar. Therefore, some other agency would be contacted to conduct the exercise. He undertakes to file a detailed affidavit before the next date stating what steps taken in that regard. Other observations are with regard to other opposite parties, my lord. Our affidavit we have stated in para 3, my lord, that in obedience to the aforesaid order of the Honorable Court, the Director Acharya Hariyar Postgraduate Institute of Cancer was requested by letter number such and such to intimate the department on 2 points. The status of approval from the Atomic Energy Commission for installation, operation and other incidental activities for installation of the CT-PET scan facility at Cuttack, and 2 is suggest the name of an alternative agency who can be approached for conducting feasibility study for installation of similar equipments facility at Baleswar and Berhampur, so that it can be done as it could not be done by AIMS, my lord. In reply to that, my lord, Annexure B by 1, my lord, by data dated 1/2/2022, it was intimated that the delivery would start from 3rd.
So who's, I think Mr. Devashish Panda is here, sir.
Yes, he's for the.
Yes, my lords, I am there, my lords. We
yes,
have
tell us.
already we have received the equipment, my lords, on the 6th of April.
Okay. Very good.
And they have given a timeline that by 20th of June it will be functional.
All right.
Because some permission has to be obtained from the Atomic Energy and others. They
All
have
right.
just commenced opening the equipment from the boxes.
All right. Mr. Devashish Panda appearing for the Acharya Harihar Postgraduate Institute of Cancer, bracket AHP GIC, states that the equipment has been received on 6th April and they are in the process of unpacking and installing the equipment. He further states on instructions that approval from the Atomic Energy Commission for operating this equipment and other incidental activities is awaited. It is expected to be.
As per their timeline, Millers, they have said 29th June 2022 will be
The timeline given is that by 29th June 2022, the equipment will become operational. What about the other cities?
Yes, as regards Baleswar and Berhampur, but you may kindly see para 3 in the last portion we have said the equipment delivery would start from 3rd week of February 2022. The main equipment delivery would be from 2nd week of March 2022, and the system installation will be within March 2022. Further, the necessary approval from the Atomic Energy Regulatory
No,
Board.
but what has happened here? Delivery, has it happened? Not happened.
My lord, will be the permission will be by end of February, my lord, and the
Sir, we are in mid-April.
my lord. This affidavit was filed, my lord, pursuant to lordship direction in the month of February.
No,
my
so
lord.
you have to give us the today's
Yes,
position.
today's
Please.
position,
You can't
my
give
lord.
us a 2-month-old position.
My lord, certain development must have taken place, my lord, if your lordship grants a short
Council for the
adjournment.
state needs some more time to update the court on the current status of procurement of equipments.
My lord.
For the medical facilities at Baleshwar and
Berhampur.
Madam, as regards the Bhubaneswar Jasper is concerned, they have almost stated earlier that it will take 2 years. Now more than 1 year has been passed in the meantime. What step they have taken regarding Jharsuguda and Bhubaneswar also.
Jharsuguda.
Yes, Jharsuguda. They already agreed for that.
Also.
Jharsuguda and Bhubaneswar.
As far as Jharsuguda and Bhubaneswar is concerned, that they had already given their consent and that approval was also obtained
Alright.
from the state government, but they are silent on that.
They will also file, apart from filing an affidavit regarding the above equipments in the above 2 cities.
Yes, ma'am.
The state government will also inform by way of an affidavit to be filed 1 week prior to the next date of procuring and installing similar equipments at Jharsuguda and Bhubaneswar.
At Bhubaneswar, yes.
List on 11 July, sir.
Lords, may I submit one thing?
Yes, please.
The equipment is supplied by Siemens Millers.
Yes.
I think it will take some more time, Millers, for Siemens to give all these necessary equipment. I don't think by 11th July.
At least some progress would have been made, Mr. Panda. Whatever
Yes,
progress
that-
is, yeah, all right.
No, as far as Cuttack is concerned, he has already said by 29th of June it will be completed. So as
Very
far
correct.
as cities are concerned, that may take time. We have no objection.
All right, 11 July.
Supplementary.
Maple Leaf Lordship, I have got small submission to be made. I am appearing for Maitri Sansad, a later petitioner in this case. I have also raised similar issue as has been raised by the petitioner, and other issues have been raised. And in the meanwhile, the counter has already been filed by OP number 3, that is Acharya Hariyar. And I have also filed a rejoinder mailer, and a reply has been given. So that in the reply they have admitted that Lilac building, 7-story building, is under construction. But the present status of the same should be indicated by them. Only because if that building will be completed, 50% problem of the cancer patient will be solved. Only because now the patients are lying on the floor, mailer.
Where is this?
Acharya Hariyar.
You respect Millers, the Linac building. Millers, in the Linac building, this equipment is going to be installed. Besides, other equipment are also going to be installed.
No, he's saying patients are in the floor in your hospital.
On the studio.
That was at that time, Millers. At present, that situation doesn't
For
exist.
20, I will kindly bear with you for a moment. In 2020, I am 1 year in the hospital. Hundreds of patients are lying on the road, not on the floor, near the road, where the vehicles are moving. I am the victim. I spent 1 year in 2020 in the Acharya area hospital. All are sleeping and sitting in the roadside, man, where the vehicles are moving.
All right.
I am eyewitness to that occurrence and that scenes. I am seen since 1 year, man. In summer, in rainy seasons, in winter season, all the seasons they are sitting on the roads.
Are there plans for expansion, Mr. Panda? Mr. Panda?
Of course, Millers. Of course, Millers. Expansion plans are on.
But what are those plans? What is the timeline for that?
So in my counter affidavit, I have given details, Millers. If your lordship will look at my counter affidavit. Just a moment. The first counter affidavit which I filed before your lordship was on 28/1/2021, Millers. In that counter affidavit, I have made a statement at paragraph 11 about the PET-CT scan facility, Millers. I have filed another counter affidavit, Millers, before this honorable court. That is on 23rd of February, Millers. There I have stated about the e-tender which was floated for the machine. Then with regard to my learned friend Maitri Sansad's allegations, Millers, there also I have filed a counter affidavit wherein I have stated that the state government has taken steps to upgrade the facilities in Acharya Hariyar Cancer Institute, Millers, and progress is going on with respect of
No, no, Mr. Panda, this is about expansion. He says there's not enough space for the patients. Many of them are out on the roads.
That your lordship may see my reply affidavit to the petitioner's rejoinder. I have stated that dated 2/7/2021, Millers. No, I'm sorry, that is with regard to Mr. Budhia's allegations. Just a moment, your lordship.
Not allegation, the grievances before this court. The general public, I am not allegation to any particular point because I am the victim.
Mr. Panda, why don't you file an affidavit on the expansion plans?
I'll do that.
Mr. Panda states
By
that
11th of
as
July.
regards the expansion plans of the ACPGHI, he will file a separate affidavit. indicating the timelines within which the expansion activities will be completed. All right.
Supplementary list item number 23.
May I please, Your Lordship? Your Lordship, in this case, I have received the counter affidavit filed by the opposite party number 3, but I'm waiting for the affidavit from opposite party number 1 and 2. But if Your Lordship desires, then this case can be disposed of, because the point lies that the State Bank of India, which is the opposite party number 3, inadvertently actually made the mistake in registering my address, and they have admitted so. If Your Lordship kindly peruses their counter affidavit, page number 45.
Yes.
The document that they have attached against my address proof is this, but they have made the mistake, as Your Lordship would kindly peruse page number 40 of my petition, the annexure.
Right.
Your Lordship, the address is different. So this difference has been made by them. That has led to the delay, Your Lordship. So the prayer is that if the fine on account of that can be waived off, then things will fall in place, Your Lordship.
Or in the counter affidavit filed by the State Bank of India.
For SBI, I'm appearing, my lords, for OP number 3.
Which where is the counter affidavit?
Counter affidavit of OP number 3, my lords.
Where is that?
Which my learned friend has just referred to, page 45, my lords. Our counter affidavit filed on 23rd December, my lords, 2021.
Which paragraph, sir?
My lord, is showing the same document I was referring to, page number 45.
45.
Lords, actually, my lords, SBI's role is limited to the extent, my lords, only our averment is that we had well in advance opened the account, that is on 19/5/2021, and that is also admitted by the petitioner. And petitioner had a time duration that we have mentioned in page 8 of our counter affidavit, the first para, my lords. The existing address could have changed at a later stage. The petitioner had the time duration of 19/5/2021 to 36/2021. But thereafter also the petitioner within that time period was not able to file the annual return because of his lapses and all. So and regarding that address part, which my learned friend for the petitioner has said that there is an inadvertent error on the part of the SBI, that is not the fact, my lords, because we have mentioned that in our counter affidavit specifically. If my lords may refer to page 7, my lords, while filing of the form for that in that regard, my lords, he had mentioned the earlier account number that was previously held by the petitioner with the State Bank of India, my lords. At subclause B, my lords, starting at page 7 of the counter affidavit, that the relation with SBI is established through the initial stage of customer identification file creation through electronic mode. The existing relation.
What are you proposing, sir? You want the petition to be disposed of, saying you've admitted there is a mistake, you will correct it.
Lords may direct, my lords may dispose of on this consideration, my lords. We have limited role, my lords. No fault of the SBI. That is only my submission, my lords.
He wants you to correct the address, please.
My lord, that has been corrected.
Not. That's a simple question.
My lord, that has been corrected. They corrected it beyond the date of last date of filing the returns, Your Lordship. That's why the fine has been imposed. My submission is that since the mistake was committed by SBI, which didn't allow me to submit it on time, that's why the prayer is to waive the fine. My lord.
All right. Submission was there is no fault of SBI, my lords, regarding the.
Your Lordship, the address that was furnished at page 45 is the address should have been registered, Your Lordship. Since this is an FCRA account, the address needed to be accurate as it is in the registration certificate, Your Lordship. It is also mentioned there registered office address in India because it is an FCRA account. It was specifically instructed to open an FCRA account in a specific branch of Delhi. For that, we have submitted this address. They have inadvertently made the mistake, and we told them
from the counter affidavit filed by SBI, it appears that there was a genuine mistake made in entering the correct address of the petitioner in the account.
My lord.
Full stop. This has prevented the petitioner from submitting its FCRA returns and other documents as required by the Foreign Contribution Regulation Rules 2011 from being uploaded. Full stop. Paragraph. That way, the matter counsel appearing for the SBI states that they will carry out the necessary rectification in the accounts of the petitioner within a period of 10 days from today. Paragraph. Since the only reason for the petitioner not being able to upload its details under the FCR rules was the mistake in the recording of its address in its account. Come on. Once the account is rectified, once the address in the account is rectified, it will be open to the petitioner.
Your lordship, it has been rectified, but they rectified it beyond the last date.
Yeah, since it has now been rectified, it will be open to the petitioner to resubmit the returns in physical form to the Secretary of Ministry of Home Affairs.
Your lordship, this is an FCRA wing of Ministry of Home Affairs.
Ministry of Home Affairs on the strength of this order. If such physical returns are submitted not later than 9th May 2022, it shall be processed in accordance with law. Mr. Pari,
my lord, a sentence regarding waiving of the fine, a sentence regarding waiving of the fine they have imposed on that account.
Any fine that is payable by the petitioner on the above for the delay in filing the returns and other documents will be waived by the Ministry of Home Affairs.
Deeply obliged.
A copy of this order will be communicated by Shri Pari, learned ASGI, to the Ministry of Home Affairs forthwith.
May only omit that sentence since it has already been rectified, the address part.
Yeah. All right.
Supplementary item 24.
So 24, my lords, I am praying for 2 weeks time to file on behalf of the revenue.
All right.
File the counter.
Final opportunity to file a reply within 8 weeks.
Interim order continued.
We're joined for the next 8 interim orders to continue. List on 10th August.
Supplementary list for hearing item 25.
So 25, I appear for respond number 1.
Yes.
1 and 3. Now, Lord, if your lordships recall, on Lord 8th of December, your lordships had given them time to file a rejoinder.
Correct.
That rejoinder is not filed, but yesterday, Lord, we have been served with an amendment application.
Oh.
Now, Lord, I have no problem. Let them amend the petition. My only request to your lordships is your lordship may fix it on a particular day for hearing because the interim relief is continuing in their favor.
What is this amendment application? Who has filed it?
No, that amendment has been allowed, my lord. It's a consolidated writ.
Consolidated writ amendment was allowed.
Oh, yes.
Yesterday, they have given us a copy of the consolidated writ application.
All right, Mr. Kulkarni.
Permit me.
Sorry, Mr. Natkarni, learned ASGI, states that the consolidated writ petitions were served on his office only yesterday. That is the matter list for final hearing.
So you will kindly take up one thing, my lord. I am also there in item number 2 and 3. But you also kindly have a look at the order dated 11/6/2021. Mr. Colonel Vishal Singh, the director, also interacted with your lordship members in virtual hearing.
Yes.
This that matter, my lord.
Correct.
They are supposed to file a report.
Ex-servicemen, tenders.
Yes, my lord. And they are supposed to file a counter in this case, and you also directed them to file any return. Anything you have to say, you have to file it in the affidavit. Till that, nothing has been filed. But in Delhi High Court, they have already filed.
No. Composite affidavit has been filed, not in this matter. Not on 3rd of December, it has been filed and they were supposed to rejoin to that. They have not rejoined.
They have not filed till date. Mr. Padhi has to, but the other party to undertake that they'll file it.
DGR has to file, my lords. DGR has to file.
DGR has to file, Mr. Adkarni.
All right.
DGR to file.
Who has filed? Has the DGR filed?
No, my lord, DGR has not filed.
Mr. Padhi?
DGR has not filed any affidavit, your lordship. The counter has not been filed by the DGR.
Yeah, so Mr. Padhi, who's appearing?
He has some personal difficulties, my lord. So 2 weeks time to file the reply, my lord.
Oh, I see. It appears that the Director General for Rehabilitation, right?
Resettlement. my lord.
Resettlement, sorry, resettlement. Bracket DGR is yet to file the reply to any of these petitions. The reply of the DGR is essential for deciding the present petitions. Accordingly, it is directed that the DGR will file its affidavit, reply affidavit to the petitions positively on or before 1st June 2022. Rejoinders there to be filed before the next date. 23rd August,
yes,
a Tuesday.
Much obliged.
My lords, may
But there's just one request. Your lordships have referred this one as ASGI. My term is over, so now I have relinquished. Happier now without that.
You are sounding more relaxed. I see. All right.
one more submission, lordship.
All right.
One more submission, lordship.
Yes.
On last occasion, we had filed our consolidated affidavit.
Right.
No reply has been filed by the petitioners to the consolidated. If they want to file, they can file it. Last chance may given for that.
We also filed the rejoinder to that consolidated counter.
On last
Yeah,
occasion,
yeah.
lordship,
Rejoinders be filed to all affidavits, you see, by the next. All right.
Like, grateful,
Order to
Jawad.
continue, my lord.
Yes, interim orders to continue.
Grateful,
Correct,
yes.
correct.
Much obliged, your lordship.
All right. Right, sir.